We're going to hear
Yes.
some dynamic stuff from these panelists today. I've been kind of reading some of their writings, and I've introduced myself to some of them. I knew others, so I didn't go through the formal introduction with those who I know, those who I've spent some time with before, but it's so good to reach out to Professors Crosby, Roithmayr, and my third one that I talked to last night. From Brown. Come on now. Come on. Fancoise Hamlin. That's
Yes.
Yeah.
Oh, an amazing lineup. I'm so excited to hear all of you. Hello, Emily, Michelle, everybody. So, look, it gave us.
Sounds like you gave the law review a great list of names and others to contact Professor Capenda. Sounds like it, at least. It sounds like it. I don't know.
But you know,
but I've learned that the unfortunate part about it is that we have such a brief time with them. I mean, we got some native Mississippians here who have gone out and are doing great things and writing and telling stories about Mississippi and the history of Mississippi, and I want them to help us talk about how we're going to make Mississippi even better than what they left it, Michelle, and how we can move forward. And I appreciate the law review for putting together this particular symposium at this particular time. I mean, because the law review has the option. It's solely there.
That's right.
They can choose to do whatever they want to do to highlight the year, or I don't know how often they do this. I don't know if they do it one in the fall and in the spring, but this is a big symposium for the law review and the law school community. And as far as I know, the executive staff or the people who are in control of the law review, they determine what the issue, what it is that we want to highlight during our term, and they've chosen a very timely topic that is timeless. You can do this topic. Unfortunately, you can do this topic every day in Mississippi and not cover all that needs to be covered.
I will say, Judge Reeves, absolutely. When we were deciding, it was like unanimous when we were deciding on the topic amongst the executive board. And once someone mentioned it, everybody, we were like, yes, absolutely, this is it. And we're so thankful again to Professor Capenda for providing that list of these great speakers. And we're so thankful to you for agreeing to moderate this event as well.
Man, I'm just standing in the galley. I'm just standing back. I'm ready to hear from these folk, and I hear myself enough. Trust me, I'm told that all the time anyway.
Morning, Judge Reeves.
Good morning.
This is Pat Bennett.
Hi, Dean Bennett. How you doing?
Hi, Pat Bennett. You almost got it right the first time.
No, you're Dean Bennett.
Thank you for serving as the moderator today.
Oh, thank you I really appreciate the invitation.
Okay, well, we're looking forward to it. Hopefully we'll have good attendance.
I think you will. I see names of folk who I haven't seen in a long time. So
before we get started, everybody, so we are recording the session. So if you would like to share it after the fact, just reach out to lawreview@mc.edu and we can share both panels today. So just reach out to us. It's going to be recorded and we'll get started here shortly. But hey, Dean Bennett.
Good morning, Bud. Thanks to you and your staff for putting together these panels today.
A real big shout out to our managing editor, Mackenzie Ellis. She did a lot of hard work, and I'm going to mention her in a minute here, but a lot of hard work this year to get this together.
Well, we appreciate you all. Thank you.
All right, it's 9:30, so we're going to go ahead and get started, everyone. Good morning and welcome.
Good morning.
Good morning.
Welcome to the Mississippi College Law Review's annual symposium. My name is Bud Shepard, and it has been my honor to serve this year as editor-in-chief of the Mississippi College Law Review. And we're so thankful for your support this year, and we appreciate you joining us today. Last September, we began our term hosting a 4-part symposium series on the opioid epidemic. And today, we close this incredible year with an informative 2-panel discussion on racial justice in Mississippi. If you are interested in further supporting the Law Review by subscribing to our publication, please email me at lawreview@mc.edu. Volume 39 is complete and can be mailed to you immediately. Next year, in Volume 40, we will devote an entire issue to this symposium, and I expect many of our panelists will author articles. I want to welcome our guest moderator, Judge Carlton Reeves, and our distinguished panelists. We have renowned speakers joining us today from nearly all U.S. time zones. So thank you for your valuable time. Managing Editor Mackenzie Ellis will now provide introductions for our moderator and panelists. Thank you. Mackenzie?
Good morning, everybody. I'm so happy to see all of you here. I don't know if y'all can hear the popping in of people, so if you hear noises, it's people coming in. I'm so glad that y'all are all here. I do want to say very quickly that we had one panelist, Jade Craig, who was confirmed and on the flyers, but he had a work emergency this morning and won't be able to join us, so we will miss him. But we still have several great panelists. So I want to first start by introducing Judge Carlton Reeves. Honorable Judge Carlton Reeves is a United States District Court Judge for the United States District for the Southern District of Mississippi and was nominated by President Barack Obama. Judge Reeves received his JD from the University of Virginia School of Law, where he was a Ritter Scholar. He received his bachelor's degree from Jackson State University. Judge Reeves was a clerk for the Mississippi Supreme Court under Justice Reuben V. Anderson, who was the first Black judge to serve on the Mississippi Supreme Court. After clerking, he became a staff attorney for the Supreme Court of Mississippi. Following that, he worked as an associate at Phelps Dunbar, served as chief of the Civil Division for the Office of the United States Attorney for the Southern District of Mississippi, and ran his own firm, Pygott Reeves Johnson. Next, I would like to introduce you to our distinguished speakers on our first panel, a conversation on race, law, and current events. This will feature Julian Miller, Michelle Deardorff, Louwlynn Williams, and Daria Roithmayr. First, we have Professor Julian Miller. Professor Miller is a senior associate attorney at Foreman, Watkins & Croots in Jackson, Mississippi. He attended Harvard University, where he earned his undergraduate degree. While at Harvard, Professor Miller served as a staff writer for the Harvard Political Review and a staff writer for Remix magazine. He was the recipient of the Marvin C. Pittman Award for Outstanding and Most Dedicated Senior, a Ron Brown Scholar, a Jackie Robinson Scholar, and a National Merit Achievement Scholar. He then went on to graduate from the University of Mississippi School of Law, where he graduated cum laude. Professor Miller currently serves as the founding executive director of the Reuben V. Anderson Center for Justice in Tougaloo, Mississippi. Additionally, Professor Miller is the co-founder and executive director of the Delta Fresh Foods Initiative in Cleveland, Mississippi. He also serves Tougaloo College as Assistant Professor of Political Science and Mississippi College School of Law as an adjunct professor. Professor Miller is the founder of the Education Law and Policy Clinic at Mississippi College School of Law. Previously, Professor Miller served as a judicial law clerk to presiding Justice Kenneth Griffiths on the Mississippi Court of Appeals. Professor Miller is well publicized in a variety of topics, including civil appeals, rural health, and rural economic revitalization. Professor Miller doesn't just have authorship about these topics, however. He also is very active in pro bono work, volunteerism, and community service. He serves on the boards of 7 charitable and reform organizations across the state of Mississippi. Next, we have Dr. Michelle Deardorff. Dr. Deardorff is an Adolph S. Oakes Professor of Government and Department Head of Political Science and Public Service at the University of Tennessee at Chattanooga. Since earning her PhD from Miami University, Dr. Deardorff's teaching and research have focused on the constitutional and statutory protections surrounding gender and race, as well as exploring the insights provided by political theory. She teaches classes in constitutional law, judicial politics, and political philosophy and theory. Before going to UTC, Dr. Deardorff spent a decade teaching at Jackson State University and another 12 years at Millikan University, a small private college in Illinois, where she served as the Griswold Distinguished Professor of Political Science for 2 terms. She is a founding faculty member of the Fannie Lou Hamer National Institute on Citizenship and Democracy, a coalition of academics who promote civic engagement and popular sovereignty through the study of the struggle for civil rights in the United States. Her 22-year engagement with these colleagues resulted in the provision of pedagogical resources, workshops, tours, and 2 museums, all designed for K-12 educators, community college and university faculty, students, and community members to understand the promise of democracy. She has served on the American Political Science Association's Governing Council, was elected vice president in 2020, and governed as the chair of the Political Science Education section of the APSA. She is on the editorial boards of Political Science and Politics, the Journal of Political Science Education and College Teaching, as well as on the advisory board of the Consortium for Intercampus Scholarship and Research. In 2019, Dr. Deardorff was named as a Fulbright Senior Specialist, which includes work with several universities in Albania. Dr. Deardorff is the author of Pregnancy and the American Worker, published in 2016, which examines the lower federal court's interpretation of 2 competing statutory interpretations of equality, Civil Rights Act of 1964 and the American with Disabilities Act of 1990, in relationship to pregnancy protections and employment. The book was co-authored with James Dahl of the University of Illinois. In 2009, APSA published Assessment in Political Science, the first primer on programmatic and classroom assessment within the discipline, co-edited by Dr. Deardorff, Kirsten Hammond, and John Ishama. Dr. Deardorff has published a number of essays and articles addressing questions of political philosophy, pedagogy, and constitutional law in a variety of peer-reviewed journals and law reviews. Next, we have Professor Louwlynn Williams. Professor Williams grew up in Brookhaven, Mississippi, surrounded and nurtured by multi-generations of family who instilled in her Christian principles and a heart to serve others. After graduation from high school, she went on to attend the Jackson State University with honors, where she graduated with honors, and the University of Mississippi Medical Center, followed by the Mississippi College School of Law. After law school, she clerked for the Mississippi Court of Appeals and was an associate at Phelps Dunbar before becoming a staff attorney with the Office of Capital Post-Conviction Counsel. Professor Williams served as an executive director of the Office of Capital Post-Conviction Counsel from 2013 to 2017. She is currently the owner of L.V. Williams Law, where she practices in the areas of chancery, criminal, and civil litigation, including employment law, criminal appeals, and domestic relations. She has over 20 years of experience practicing in both state and federal courts at the trial and appellate level. Professor Williams is admitted to practice in all Mississippi state and federal courts, the United States Fifth Circuit Court of Appeals, and the United States Supreme Court. She also serves as an adjunct faculty member at Mississippi College School of Law. She enjoys spending time with her family and enjoys music, gardening, sports, and readings. Professor Williams is a member of New Hope Missionary Baptist Church in Brookhaven, Mississippi, and has 1 daughter. Her motto is, "To whom much is given, much is required." Luke 12:48. Lastly, but not least, we have Dr. Roithmayr. Ms. Roithmayr teaches and writes about persistent structural racism in labor, housing, political participation, wealth, and education. Her most recent book, Reproducing Racism: How Everyday Choices Lock in White Advantage, published in 2014, explores the self-reinforcing dynamics of persistent racial inequality. Her work is heavily interdisciplinary, drawing from economics, sociology, political theory, history, and complex systems theory. She is currently at work on a new book, Racism Pays, which explores the way that recent innovations in the digital economy have relied on racial exploitation to get off the ground. Before joining USC Gould, Roithmayr taught for 9 years at the University of Illinois College of Law. She has also been a visiting researcher at Harvard University and a visiting law professor at the University of Michigan, Georgetown, and Yale. Ms. Roithmayr received her BS from UCLA and her JD, magna cum laude, from the Georgetown University Law Center, where she was a member of the Order of the Coif and served as an editor of the Georgetown Law Journal. She clerked for the Honorable Marvin J. Garbus, Judge of the U.S. District Court for the District of Maryland. I would like everyone to join me in welcoming our speakers. I know that was a long spill, but they're very qualified and we're very happy to have everyone here. And Judge Reeves, you're welcome to begin when you're ready.
All right. Thank you so much, Mackenzie, for those wonderful introductions. My duty here today is just to sort of play traffic cop and sort of lead people, and not even lead people, I don't know what I'm going to do. We've not rehearsed this. It is just so good, as I was telling Bud, and some of you probably even heard what I was saying earlier. I do appreciate the Law Review for dedicating a symposium to this topic. This is, as I told them, a timely topic and a timeless topic for not only Mississippi, but for our country. Our country has been dealing with the issue of race since I guess we'll say since 1492, when we claimed that Columbus came and discovered something that was over here long before the Spaniards and the Italians and everyone else decided to lay their flagpoles. But certainly since 1619, the issue of race has been paramount in this country. And as a component of that, trying to figure out how to do justice with these beings since 1619 has been perplexing for the country from its founding in 1619, basically through the adoption of the Articles of Confederation to the adoption of the United States Constitution. And from that point through Reconstruction, a whole war was fought about.
What's the last name?
Robinson.
Oh, I'm sorry.
Perfect.
T-H-E-R-E.
Okay. A war was fought about how to deal with these enslaved individuals, and once they became free, how they would be put into the community to make this a more perfect union. And then there was a fight afterward, because these newly freed people could exercise their rights. And for those who know a little bit about our history here in Mississippi and the southern states, for decades, it was African-American people who were the majority in many of these states, and that caused fear among the property owners, among those in power. So you had the backlash to the Reconstruction. And then you had the period of the early 20th century trying to, again, get newfound freedom from that point all the way up to the 1965 Voting Rights Act and so forth and so on. And here today, in 2021, the subject of race is still so critical to how our country evolves. And as you historians know, we all understand that the United States is a very young country. It's only, it's less than 400 years old. And if you read about the Roman Empire, if you read about the Greeks, if you read about the African countries, they've been here for hundreds and millennia, hundreds and thousands of years. So we're still learning where we are, but we're trying to remain true to our goal of making our country a more perfect country. So as moderator today, I'm just going to allow these scholarly people to jump in and share their thoughts about issues. We got a lot of ground to cover in such short time to cover the ground that we sort of mapped out in our minds. But race is involved in every facet of our society. Everyone. And we're not going to even tip the iceberg to talk about all the facets. We've decided to pick a few, but mind you, race is involved in every facet of our society. And here in Mississippi, we have the myopic view, sort of, like me. I grew up here. My view of race has been carved by my growing up in a place called Yazoo City. For those who know me, you knew I was going to throw in Yazoo City. My view of race is black and white because that's how I grew up. But we know, and we're going to hear from Dr. Roithmayr, who grew up in Mississippi too. And she has a totally different experience as a Latina. So I'm going to start with Dr. Roithmayr. I'm going to start with her because she talks about the structural components of race. And she talks and she writes about being locked in our situations and how they permeate all the things that we do. And as she begins to talk, we'll invite others into the conversation. And again, if this does not go off like the law review planned it to go off, y'all blame the judge. Blame the judge. Blame the judge. I can take it. I won't be mad or anything, but blame the judge. Do not at all criticize these great people for devoting this time to it. So, Dr. Roithmayr, tell us anything you want to tell us initially, but end up with the point of you sort of introducing us to this concept of being this locked in stuff that you've been writing about and the current book that you have. And again, I always want to remain hopeful. And I hope all the panelists will talk about, again, the Mississippi that they know and studied about, but most importantly, how we can make Mississippi more perfect, how we can make Mississippi better. So Dr. Roithmayr, come to us in your own way right now.
Thank you so much, Judge Reeves. It's such an honor to be here. I have Angela Mae Capenda to thank for that. As Judge Reeves mentioned, I grew up in Mississippi, Moss Point, Mississippi, down the street from Eddie Glaude. I taught high school at Moss Point High School before I went to law school, which informs a lot of the views that I have about public education. And that plays a role in the concepts that Judge Reeves mentioned that I just want to briefly touch on as a prelude to talking about the way forward for my home state. I still have family in my home state. I come back every year and I'm deeply devoted to the state. Eddie and I have been talking about coming back and doing some work on structural racism and a number of other things. But the general argument is that racial inequality is structurally locked in owing to a set of dynamic forces that automatically reproduces racial inequality from generation to generation, even in the absence of intentional discrimination. I'm not arguing that intentional discrimination has ended, but if it were to end tomorrow, if we were able to wave a magic wand, the racial gaps that characterize Mississippi and much of the nation would, for the most part, persist. And the reason is one that's pretty intuitive if you think about the way that neighborhoods and public schools determines people's future. So you start with a Mississippi that was deeply segregated, not just by race, but by wealth and income. And so the kind of wealth that whites enjoyed in the aftermath of a cotton economy that depended on racially exploiting African Americans persists because of a number of feedback loops that you can explain by thinking just of the way in which the rich get richer and the poor get poorer. And so if you start with a population in which whites have 10 times the wealth that Blacks and Latinos and some Asian groups do, it becomes obvious that if it takes money to make money, if you need wealth to get a college education, to buy a house, to buy land, to start a small business, to finance a public school system that is cutting edge, then those racial wealth gaps, along with residential segregation, and that includes rural and urban, as well as the segregation in cities, those reproduce themselves over time. So thinking about it just in terms of public education, if you grow up in the Delta and you're financing public schools on the basis of the wealth of the local communities, those public schools are going to be underfinanced relative to the public schools, say, of Ocean Springs, Mississippi, which is near where I grew up, a largely white and pretty affluent community. And so the racial wealth gaps, the housing, racial housing gaps, racial employment gaps, racial education gaps reproduce themselves over time because it takes money to make money, and because money, and in particularly wealth and residential segregation, determines so much of a child's future. I have a bunch of ideas about how to address those gaps. One way, just to mention one potential solution, is to do what many states have done, which is to decouple, to disconnect financing public school education from the local property taxes of the community, and instead to put the money in one central pot and then to distribute that money on the basis of need. So Moss Point High School would get more money than Ocean Springs High School because of the needs of the community. And in that way, just disconnecting the connection between local wealth and public school education, we can start to equalize educational opportunity and educational financing. One other option is for Mississippi to create what other states and other countries have created, children's trust funds. So in the UK, for example, for a while, every child at birth was given 500 pounds, 700 pounds if they were from a needy family, and then another 500 or 700 pounds at the age of 7. And that money was put in an account that the family could contribute to, but couldn't touch. The government matched contributions to the extent that the family was able to contribute. And that money was available to the child at the age of 18, but only for college education, a down payment on a house, or retirement. And essentially, this mimics the kind of trust funds, both formal trust funds and informal trust funds, that white families are able to give their children. And this passing down of wealth is another way in which racialized wealth gaps are reproduced from generation to generation. Why not jumpstart the wealth of Mississippi's children, and in particular, those who don't enjoy the advantages of wealth owing to the country and the state's long and sordid history of racial discrimination, try to equalize that by creating feedback loops that work in favor of African Americans, Latinos, and some Asian groups instead of against them. So I'll stop there.
Oh, thank you, Professor. I'm gonna put a pin in this. When you talk about wealth, and we're gonna talk about that through the context of what some of these others say, just think about how one creates wealth. One creates wealth through owning property, through accumulating property, and passing it down to the next generation. Now, guess what? Slaves had no right to do that. They could not own property. Number one.
They were the property.
They were the property. They could not pass down anything other than women bore children to give to the property owner, and that person became even more wealthy because they owned that piece of property. So people cannot decouple, as you say, where we were back then, because for generations, African Americans had no ability to accumulate wealth, and even no ability to obtain the wherewithal to even get wealth. We have to remember now, it was against the law for Black people to even read. And it was criminalized for those who even try to teach them to read. Structural racism and the impact structural racism has on where we are at any point in time. You mentioned, you were talking about basically secondary education, high school, elementary. I'm going to move just a minute to get Professor Miller, or Julian, as I call him, and I'm certainly sure he don't mind me calling, because I know him in that kind of way. I'm going to invite Julian into the conversation because to talk more about a little bit more about education, and we know that there's a gap in trying to achieve access to higher education. So I'll get you jump on in, Julian, if you will.
Thank you, Your Honor. I appreciate it. Yes, you can call me whatever you like. I think when we talk about, and thank you, Professor, I thought that was absolutely beautiful as far as how we restructure our public education system not to not be essentially driven by property taxes. Again, I think it should be something that's universal, not just for K through 12 education, but also for higher education. But I think it's important to understand to understand sort of this idea of universal rights around education in particular as a social good. I think it's, particularly for Mississippi, I think it's important to understand sort of the context of how our education system worked based upon this, again, this great summary that you gave, Your Honor, about our history of race and Jim Crow and slavery to where we are to the present. Basically, our education system, of course, Mississippi, we're at the bottom when it comes to education, and certainly with higher education, that's well known. But I think that what's not as known is that how we got here, that was very deliberate. It was very, very deliberate. Before the Civil War, the merchant families on the coast sort of had this kind of, I guess you call it a gentleman's agreement with the planter families in the North. And the idea of it was, that, okay, looks like, at the time, of course, back in that, before the Civil War, the Mississippi was the wealthiest state in the country because of agricultural exports. So the idea of it was, so these planter families, these merchant families got together, like, hey, look, looks like agriculture is going to decay. We're going to be wealthy forever and ever. This is the way it's going to be. We've got to try to, this whole Civil War thing is coming and everything doesn't work out. We got to try to figure out how we essentially can continue to exploit labor in order to sort of maintain our wealth. So the idea was, okay, so we won't have a formal public education system. And what we'll do is we'll send our kids to be educated overseas or in the Northeast. We'll have a low tax base, so we won't build any type of physical infrastructure, let alone educational infrastructure. And so after the Civil War and with the advent of the Readmission Act of 1868, it was required for all Southern states that had to readmit back in the Union to have a provision in their Constitution that allowed for an establishment of free and universal public schools. And so Mississippi was the second to adopt it in its 1868 Constitution. But that being, even though it was adopted, the idea of it was there was still this idea of we cannot have an educated workforce. You know, it's this economy is built on the exploitation of Blacks as much as additionally the exploitation of whites as well. So what happened? We had an extremely underfunded school system where you had like religious organizations that built a patchwork of Black schools, and the public funding that went to the modest public funding that did go to primarily white schools, public schools, was so inadequate. So much so that students could not pass the entrance exams to get into the University of Mississippi and Mississippi State University, which were the two flagship public universities in Mississippi. That's why Mississippi to this day has 15 community colleges, which is only second to California. And so this was how public school system developed. And so by the time you get to 1936, Mississippi, the state of Tennessee, and I kid you not, the state of Tennessee spent more on educating its Black students than the state of Mississippi spent on educating its white students. And there was still a huge disparity in funding between Black and white schools, so much so by the time you get to 1950, only 4% of African Americans in the state actually graduated high school. So in that context, this is essentially, that has been ingrained in our system, our education system. And so where we are is not a surprise. So when we think about increasing access to higher education, I agree with the professor that we got to start with a robust public education system that's funded sufficiently to provide universal after school, to provide sufficient teacher training and support, to provide resources for special education students. That big part of the work I do in the education law and policy clinic here in MC Law. And essentially modernize in a way where students essentially graduate ready to succeed. But when we think about access to higher education in this state and across the country should be just as universal as high school. We are anomalous from any other modernized country in the world, that we actually have a public education system that essentially is funded off the backs of working families. Before the mid 70s, 87% of college costs were ultimately supported by the states. 87%. It's now down to 38%. We've gone from first and 12th in the world in the number of students attending college because of the fact that from 1993 to the present, we've seen a 65% increase in administrative costs in higher education. 65%, and now we have over $1 trillion in student debt because of the fact that we commodified our education system instead, in which we commodified every social good. So I won't go down that tangent. And so, in order for us to create access to education, we've got to fully reform our education system and fund it adequately to basically allow students to put students in a position where they can succeed. But we also have to also ultimately decommodify our education system and make sure that any child that wants to go to college, community college, or getting higher education can do it, and the government essentially pays for it. It is a right. Education should be considered a right. It is a right, and in order not only just to address it as a right, but also to mitigate the racial disparities that is inherent in the education system in Mississippi. That's the only way it can be approached.
Well, thank you, Julian. As we move again, just simple little nuggets as we transition from one speaker to the other. I spoke to a group of law school students earlier this week, and I see people who are on this call who are of my generation and people who did work to assist my generation. And I know Professor Kapenda has written about her experience of integrating Forest Hill High School, for example. For the law students on here and for the younger people on here, you have to understand when we talk about education here in Mississippi, we talk about the struggles of of Mississippi and the whole country being told in 1954 to desegregate your schools, to integrate your school through Brown versus Board of Education. But again, you lawyers, you law students, you know that there was a Brown too, which said you can do it with all deliberate speed. And for those of you who are familiar with the law, that gave many of the Southern states creative ways of figuring out what deliberate speed is. In Prince William County, Virginia, for example, what they decided to do, if I'm wrong about the county, I may be wrong about the county, but I don't think so. What they decided to do was decide that we won't have public schools anymore. We won't offer public school, period. We will not offer public schools so that to prevent Black kids from going to school with white kids. And that happened for a period of time. Here in Mississippi and other places, states adopted rules, okay, all deliberate speed. Well, we will integrate the 12th grade first, and then we'll integrate the 11th grade, and then we'll integrate the 10th grade. Again, deliberate delay. Alexander versus Holmes came down in 1969. That's the third iteration of Brown, in my view, where the Supreme Court out of Mississippi told the Supreme Court in November, December 1969, told the state of Mississippi, desegregate or integrate your schools now. So those kids who had gone home in a segregated school over the Christmas break, when they came back over the holidays in January, they were in an integrated setting. Now, mind you, integrated setting in Mississippi at the time mean that those Black principals and Black superintendents and Black people who were in charge in the Black school, they became assistant principals. They became the second class teachers. They became but they were integrated. Some of them could not still teach white students. They put in white kids, they put in Black students in the classes of white teachers in some places, but no white students in the classes of Black teachers. So come 1970, September of 1970, and this is what I told the students who I spoke to earlier this week. In Yazoo City, Mississippi, of course, I'm dropping Yazoo City again, Annie Ellis Elementary. It was the first time that Black and white kids started out in school together in the first grade. And that was in Yazoo City and throughout the state of Mississippi for the first time. Brown came down in 1954. 1970 was when it was implemented for all intents and purposes. We've been talking about education, and as I mentioned, I've sort of talked, my concept of diversity and my concept of this whole nature is Black and white, because that's what I saw. I think a Vietnamese kid started in school, in my high school class, probably when I was about in the 10th grade, and I think he came in the 9th grade. So, and I know there were some Chinese people there in Yazoo City, and there were a couple of Hispanic people there in Yazoo City, but my views have all been shaped by my views on race. But there is another component that Michelle Deardorff talks about in her writings and all, and I want to invite her into the conversation, this notion of equal protection, because the equal protection applies to all of us, race, sex, gender, national origin, and things of that matter. And Michelle spent some time here in our Mississippi, y'all. She was at she spent some time at I Love at Jackson State University. And I know Michelle, so I'm gonna call her Michelle too. See, these other people I don't know. So for those who I know, I believe I can call you by your first name, but Professor Deardorff, not to malign you in any way, please come into the conversation and tell us about the critical issues in Mississippi with respect to equal protection, which consists of gender and race.
Yeah. Well, and I think I'm going to morph it back to the larger discussion too, because the equal protection questions are the same ones we have nationally, right? It's the federal Constitution, and there's some real issues around the use of the equal protection of the law since the very beginning, since its earliest interpretations. So since the civil rights cases in 1883, the court's interpretations have been of only allowing the federal government to limit state violations of civil rights, not private violations of civil rights. And so if a state decided to either not act, to ignore the ways in which citizens violated each other's rights, often with violence, or, until we get to the Shelley versus Kramer in 48, when the state's enforcing it through the courts, private violations of civil rights, then the federal government could intervene. And so if the state of Mississippi refuses to protect citizens from private violations of civil rights, there's nothing the federal government can do. The Supreme Court, of course, in Seminole Tribe of Florida and in subsequent cases have reinforced this idea, the limited ways in which the federal government can intervene when states violate citizens' rights. I mean, I think for African Americans who've experienced continuous local and state violations of rights and have sought federal relief, this has been of great concern. But for Native Americans and Latinx communities where the oppression has been as heavily impressed by the federal government as for state and locals, it may have been a little less significance. For gender and its inclusion, that came about in Reed versus Reed in 1971, right, where the Supreme Court said that gender was protected under equal protection and that you had to treat men and women equally. But in 2011, Justice Scalia had an interview with the California lawyer where he made it clear that using original intent, he didn't think the 14th Amendment prohibited gender discrimination. And because the ERA hasn't passed, that means a Supreme Court that has 5 people who share Justice Scalia's judicial interpretation can exclude gender from equal protection under the Constitution. Mississippi isn't really known for its strong protections of gender. And so often in Mississippi, we rely on federal protections. And so this would, if we eliminate the 14th Amendment, then you're talking about just things like the Civil Rights Act of 1964 or Americans with Disabilities Act, those kinds of employment discriminations. I think the last piece has to do with all forces of law, is that our law was not established to think about intersectionality, right? It's very comparative based. So we think about that race is violated when a person of one race is treated differently from a person of another race, or gender is violated when a person of one gender is treated differently than someone of a different gender. But intersectionality tells us that life's a lot more complex than that, and that oppression can occur because of overlapping identities. But our law is not really designed to think about oppression in that kind of complex format. And so what I guess when I think about solutions, and I'll be brief on this, I'm just going to give you a quick analogy. Growing up, I grew up in Columbus, Ohio, and my family were Kentucky transplants who came to the city, and my grandparents rented this little farm right in the middle of the city next to the interstate. And there was this tree on this farm, and it was next to a fence. And as I grew up, the fence grew into the tree. And eventually, as the tree got bigger, it pulled the fence out of the ground and it got embedded in the tree. And we had to rip that fence down and rip it out of the tree, right, to save the tree's life. What happens to that tree? I mean, you've probably all seen that before, right, where the fence grows into a tree. What happens to that tree when you rip the fence out? Does it turn into a platonic notion of a tree, this perfect ideal tree, and kind of spring back to its ideal shape? Scarred. It's scarred because of its interaction with that fence. And if we don't treat the tree can die from this damage. And I think that trees are democracy. And I think that fence is our centuries of systemic racism in our nation. And even when formal equality came and we ripped the fence out, We then looked at the democracy and said, we solved it, right? We have formal equality. And if our assumptions of justice are neutral laws and neutral policies, that as long as they're applied fairly, consistently, and publicly, we have justice, we've got a problem, because a lot of those laws, a lot of those policies were established when that fence was in the tree. And the people who developed those laws and policies weren't the people who were impacted by those laws and policies. And so we now know, we talk about disparate impact, right? We now know that laws that are neutral in their nature can have really damaging implications and consequences, even if they're applied consistently to everyone. They can still reinforce structures of oppression that our previous speakers talked about. And so I think what we have to do, and I think this means every single one of us, in the lives that we lead, we have to look at the policies, the rules, the structures, the laws, the assumptions that we implement, and ask, what are the roots of these? What are the assumptions behind these? What are the implications of the way they're implemented? And that's how we have to, I think, restore our democracy, is go back and not assume a neutral law is a fair law, but ask, what was the root of this law? And I would just say this, think of Mississippi's Constitution and when it was formed and what its purpose was in its formation. It had a very clear purpose. And what have we done since then? We make changes, we change language that seems very egregious. But the values and the assumptions in that Constitution, we've never gone back and asked, is this who we are and who we want to be? I'll stop there.
Thank you, Professor Deardorff. That Constitution, I think, was adopted in 1890.
Yes, it was.
Reconstruction. So, you know, again, thinking about history and where we are, we always have to be cognizant of that point. And I'm going to invite Professor Williams in because we know, we've sort of hinted at education, employment, to some degree, housing, you know, just a number of things. But Professor Williams has the expertise in dealing with our criminal justice system. And again, race intrudes every facet of our lives. I tell people all the time, the most powerful weapon, for example, that a prosecutor has, in my view, is the power of discretion, and how he or she uses that discretion in how charging decisions are made, how plea offers are made, how cases are filed, who is prosecuted, who is given the right to seek treatment as opposed to being prosecuted. But I'm going to invite Professor Williams in to talk about access to justice and how it might be affected. And she led the post-conviction office here in Mississippi for some time, worked in that office for some time. Post-conviction means what, young lawyers, law student? That means you've been convicted. And we know that when I talk about the discretion on the pre-conviction side and throughout the process, again, race intrudes all of these things, how our public defense system is financed, how it does, and of course, the values that a judge brings to the bench, the value that jurors bring to the jury room. So, Professor Williams, I'll ask you, how has the access to justice, when we talk about race, when we talk about status, how has access to justice affected, how can you describe or articulate or whatever Mississippi's criminal justice system?
Mississippi's criminal justice system is just on the face of it, you can go sit in a courtroom on any given day, on a sentencing day or docket call, and look at the disproportionate number of minorities, the Black and brown people versus the Caucasians that are actually in the courtroom. It is the prosecutor's discretion, you know, as you mentioned, to actually push cases forward, offer plea deals. And on a disproportionate level, you see that the Black and brown people don't get those sweetheart deals. You may have two people with the same crime, even a sex crime, for instance. One person on one hand may get, if he's Black or brown, he may get the maximum sentence and have to spend that time day for day. Whereas you have a person who's Caucasian with the exact same crime, and that person may be sentenced and given house arrest or suspended sentence or things of that nature. But one of the biggest issues that are facing us with the criminal justice system, especially with regard to post-conviction, and what people have to understand is that post-conviction attaches after they have gone through the appellate process. Okay, which means I've got that sentence, I either pled to it or I got a jury verdict and was sentenced by the court. I do my direct appeal, which the Mississippi makes provisions for public defenders if you're indigent. There's a mechanism in place for direct appeals. If you're indigent, the Mississippi office of the State Public Defender's Office handles direct appeals. But once that direct appeal is done, even though there's a law on the books for post-conviction relief, you're left on your own at that point. If you can't afford to do it yourself, then you have no representation unless you're lucky enough to get something to push through the system and actually get to evidentiary hearing. Post-conviction is completely different because at this point, you're looking for things outside of the record. And if I am an incarcerated individual sitting in a jail cell, I don't have access to things that would be outside of my record, evidence, individuals that I can talk to. A post-conviction petition is evidence-based and document-based beyond what you would get from the four corners of the record. So I already am at a disadvantage there because I don't have access to it. If I file a petition on my own, pro se, I only have the information that was gathered during the course of the trial, so to speak. It's going to be denied. The Mississippi Supreme Court, on any given Thursday, you can look at all of the post-conviction petitions that have been filed pro se, and they pretty much are denied. The state doesn't have to respond to them, and oftentimes they don't. And then I'm admonished if I file one, I'm told that I can't do it again. If I try to do it again, then I'm subject to sanctions. So my access to justice has been denied. On paper, it's there, but in practice, I don't have access. And there are people and there are things that happen during the courses of trials that are violations of the Constitution. There are some innocent people who are behind bars, but their wings have totally been clipped and they don't have access to that. Money is another issue with regard to all of that because it's an expensive process. So if I don't have the funding to be able to hire an investigator or hire an expert or hire a top-notch lawyer, then my access to justice is denied, even though on paper, I have a right to this. It's just, it's heartbreaking, you know. In working at the office when I was there, we constantly would get letters from inmates requesting help, but because we only dealt with capital cases, there was nothing that we could do for them. Outside of that, there are agencies around the country now that are popping up and offering false hope to families with people that have gone through the appellate process and are now in post-conviction. If you give me this much money, we'll file a brief, we'll get them out. They have absolutely no concept whatsoever of what Mississippi law is, what the statutes are. They'll pay a lawyer a couple of $100 to put their name on the petition because, of course, you know, they're not barred in Mississippi, and push it through. Again, false hope. So there is a major issue here surrounding access to justice from a post-conviction standpoint. In other cities and other states, believe it or not, university journalism departments in other universities are creating investigatory journalism to follow cases. They go out, they get the information, and then they try to find, if they find something that they really think has merit, then they're still tasked with the process of trying to find an attorney who's willing to take the case on, or an organization that's willing to take the case on, because again, it's a money thing for the most part in with regard to it. But it's just heartbreaking to know that there's something there. There's a law there that says that you can do this. And there is an appellate rule there, which is Mississippi Rule of Appellate Procedure 22, that says that I can have this access. But in actuality, I can't. And again, there is a disproportionate number of Black and brown people who are affected by it, because these are the people who are being incarcerated. The solution, we need to develop a mechanism to assist. If we're going to have the rule, then there needs to be a mechanism for non-capital felonies to also have access to that process. You've done it for felony appeals. You've done it now for capital clients. It's time now to do it for those who are non-capital, but also have felonies for post-conviction.
Thank you, Louwlynn. I appreciate that. It reminds me of cases that I saw when I was at the state Supreme Court as a law clerk 30 years ago. One of the issues back then, I think Mississippi probably had just adopted the 270-day rule. If not, that might have come sometime later for speedy trial purposes. But for the law students, I would encourage you to do speedy trial on Westlaw, Lexis, Mississippi Supreme Court, and reverse, or however you want to.
Yeah.
And one of the things that you do on post-conviction matters, again, this is a case that has gone to trial. You've exhausted the appeal purposes on direct appeal, but the post-conviction process allows you to say that the state Supreme Court has misapplied federal law in some ways. That's one reason Curtis Flowers' case continued to have life.
It is.
Because the U.S. Supreme Court said that the Mississippi Supreme Court had misapplied Batson for the most part. And so Curtis Flowers' case remained alive. Number one, it was a capital case, but also number two, there was that opportunity for the U.S. Supreme Court to say, Mississippi Supreme Court, you've misapplied our law on how you should look at Batson violations, basically. But for your law students, I would encourage you to do that same sort of research for a speedy trial and just see the dearth of cases that the Mississippi Supreme Court has reversed for speedy trial violations. They're only a handful, no matter if people sat in jail 600, 700, 800, 1,200 days without a trial. And you talk about the misapplication of what the federal law that is on it. And that's just one component, if you will, of the criminal justice system, just one component. I'm going to move back to Professor Roithmayr because I read some of her locked up piece. And one of the things that she mentions there, and we're going to talk more about housing and income inequality, but one of the things that she's pointed out in her writings is that, look, again, let's look back. In the 1960s, the Congress shepherded through a lot of things: Voting Rights Act, Civil Rights Act, Housing, Fair Housing Act of 1968. Of course, Title VII came out of the Civil Rights Act. And the purpose behind all those was, again, to make America more perfect. And maybe they thought that maybe through the lens of 1960 glasses, they probably thought that by 2020, America would be on the right track. And so I want to ask Professor Roithmayr to talk to us a little bit about housing discrimination and how it might still be prevalent, even though I assume they passed the Fair Housing Act and all those back in 1968. Again, looking, making sure that things were better, at least by the turn of the century. Now we're almost 1/5 through this century. Is the Fair Housing Act, for example, Professor Roithmayr, still needed?
Absolutely. The Fair Housing Act is necessary for two reasons. One, contrary to what I was saying earlier, the magic wand hasn't been waved, and intentional discrimination is still very prevalent in housing as elsewhere, but maybe particularly in housing. We still see regularly racial steering, where people are steered to particular parts of the state on the basis of their race. We still see racial disparities in mortgage lending. That's a regular feature of housing discrimination. But maybe most importantly, the Fair Housing Act actually imposed, in contrast to lots of other civil rights laws, an affirmative obligation on the federal government to end housing discrimination and housing segregation. And Title VIII gives the federal government a lot more leeway. It hasn't always used it, certainly during particular administrations as compared to others. But there's a lot of latitude in allowing the federal government to undertake race-conscious housing programs that wouldn't be allowed in other settings. Again, depending on whom you have in the Supreme Court. I will say that the number one bar to equal housing and desegregated housing is that wealth gap that I was talking about before. So in Mississippi, as in other parts of the country, the main reason that African Americans and Latinos don't move into wealthy white neighborhoods is because they can't afford to do so. They don't have the money for a down payment. They can't make the mortgage payment. And that structural bar is one that I've done a lot of thinking about. One way of potentially dealing with that we think about the housing market in the way that natural law people think about the housing market. It's just a free market that it isn't regulated and people buy and sell depending on the demands of the market. But in fact, the government creates the housing market and allows some people to develop, gives people permits for development. There are all kinds of zoning requirements that create the housing market. What would happen if Mississippi insisted that if a developer wanted to get a permit to develop a relatively affluent neighborhood, the government insisted that that developer show that they were developing on that property and not somewhere else, or in that area, an affordable housing program. So multifamily housing in the wealthy white neighborhood. The research shows that mixed income neighborhoods are the best in terms of all kinds of measures. And that's showing a benefit for the wealthy as well as for those who are not as wealthy. What if government took that research seriously and insisted on inclusionary housing in order to give those developers the permits that they seek? That might be one way of getting at it. Another way of thinking about this is to reflect on what Julian was saying earlier in terms of who benefits from segregation. I think about the Nissan plant, for example, in Canton, right? So they get $1.3 billion in tax credits at the same time that the state is pulling $1.3 billion from public education. Make Nissan pay its fair share and insist on getting Nissan to participate in affordable housing. Nissan benefits from well-educated workers. It isn't, the Nissan plants of today are not the Nissan plants of 30 years ago. People who work in automotive manufacturing have to have some understanding of electronics and computer technology. To the extent that Nissan has an interest in well-educated workers in Mississippi, we know why they came, right? Because of the $1.3 billion in tax credits. But to the extent that Nissan is going to continue to profit from Mississippians' labor, and it's disproportionately, again, people of color, let them bear their fair share of the burden in funding affordable housing and robust public education systems.
So thank you. I'm gonna invite Julian back into the conversation, but you talk again, racism infecting every aspect of life. You mentioned housing and buying and renting and all that, but the mere, and I'm sure, you know, you all read the newspaper and see the news, but I imagine you saw the news story about the Austin family in San Francisco back in February. This was a young Black couple that had invested hundreds of thousands of dollars of their money into remodeling their home to put it on the market, or either to put it on the market or to get more financing or whatever. And they got the appraiser to come in to appraise their house. And they thought that the number that the appraiser gave them was remarkably low, incredibly low. They said, this cannot be the case. So they were talking to their a white couple of their friends. And their couple, the white woman said, okay, Tanisha, I will be you. Tanisha, I will be you. And I will move into your home. We will put up pictures in your home, and we will call this same appraiser out to do an appraisal on the house. And guess what? The house, from the same appraiser, the same house, the value of the house increased by more than $500,000. Nothing but race to account for that. So Julian, I shift back I shift back to you. Just that was going to be my transition point. But economic revitalization is something that you talked about a little earlier. But one of the other things that you've been talking and reading and stuff is about the disparity in health outcomes, the healthcare system. Uh, uh, and if I'm not mistaken, you are from rural Mississippi. I think you're
Yeah,
from.
the Delta, yes, sir. Yes, sir. Bolivar
I
County.
think that's real rural. I think home of sugar ditch. But tell us how economic inequality, how again race affected all aspects of life, even the ability to live. I mean, to gain health status, to increase your ability to reduce your morbidity, increase your or reduce your mortality, I guess, or however it's to be said. But go ahead,
Of course,
Julie.
of course, and I just want to, and it's a perfect segue because I could piggyback off of Professor Roithmayr and the example with, and I'll talk about the Delta, but I wanted to piggyback off her point with the example with the Nissan plant in Canton. I think it's important to note that there was a huge movement to unionize that plant for the workers that unionized the plant. It was and of course, 80% of the workers were African American, and so of course that didn't work out. But I thought when you think about economic revitalization that both addresses racial disparities as well as the need for addressing public goods such as healthcare. I think a lot of it goes around this idea of economic democracy, right? That workers who create the wealth with their labor, collective labor, and their collective consumption should not be live in squalor, should not be too poor to live. In fact, should actually gain the benefits of that wealth, right? That's why this movement around, that's why you have this movement for reparations around slavery. It's because slave labor made this state very wealthy, made the country extremely wealthy. And, now we are fast forward even now, and the Professor Roithmayr made the point about, yes, we, as far as wealth, as far as you look at income inequality, it's a 10-to-1 disparity between Black and white wealth. And if you look from just 1968 alone, while the African American middle class has tripled, as number of African American middle class families has tripled since 1968, the child poverty rate is exactly the same it was in 1968. And in the United States, there is not a single county in the United States where the minimum wage is sufficient for a family of 4 to afford a 2-bedroom apartment. In Mississippi alone, you have to have at least make $14.75 an hour as minimum wage in order to be able to afford a 2-bedroom apartment. We're still at $7.25. So it's interesting to note that we still are. It's a structural problem with our economic system, right? That we're not too far from slavery, with our economic system. In fact, what we have going on now is a phenomenon called immiseration, where we've not since about 1975. The average wage is about the same as it was since 1975, even though we've had 87% increase of productivity of workers. Workers are capturing less than 10% of their wealth. A big part of that, looking back at the example with Nissan, is because we've seen a huge decline in private sector unionization. At its peak, it was 36% of the unions were 36% of the private sector workforce. Now it's less than 7%. So, and looking at Mississippi and Mississippi Delta alone, with this immiseration phenomenon, you have people literally working harder and harder for less and less money. And so, but they can't really change jobs because we do not have the labor market, especially after what happened with COVID, the labor market is not producing enough jobs for it to tighten and for it to raise wages. So people have to work harder and harder for less and less money. And also because since the mid 70s, healthcare has gone up 2,000%. Education has gone up 1,000%, the cost of it, adjusted for inflation. Housing has gone up 500%, the cost of food has gone up 400%. Again, the average wage has gone up nothing more than 10%. So people have to be essentially enslaved and to their jobs to keep working harder and harder for less and less money in order to just to be able to survive because of the commodification of social goods, everything's costing more. So what's the solution? The solution is ultimately we should create democracy, not just in our government, but in our workplace. And we should build a movement toward having worker-owned, cooperatives. In Spain, for example, the 7th largest corporation is the Mondragon Corporation, which employs over 100,000 people. And they have, essentially their workers get together a year and they vote who their CEO should be, who their manager should be, and their management can make 7 times more than they make as workers. In the United States, it's 300 to 1 workers to CEOs as far as Spain. It's 7 to 1 in Mondragon. And like I said, they are secure of their job. They have extremely high wages. And again, but they make sure that wealth goes out to support social goods, to make sure it pays for universal health care, education, and other social services. So one of the things I'm doing as part of the Anderson Center is we're doing work on cooperatives. We're developing a community food system at Tougaloo College, looking to basically capture the $1.2 billion food market, which in the Delta, only 0.004% of local farmers capture that market. We're looking to create a food system where in these rural communities in the Delta, and of course, we're starting in Tougaloo College, where essentially the workers grow the food and sell it and create a sustainable market about it, and they get the wealth. They essentially get the wealth of it. And so that not only addresses, again, looking at dealing with these economic disparities, but also addressing public health. Again, in the Delta, where I'm from, we have indicators of health which are comparable to third world countries. And before I started law school, I did work as a community organizer. And one of the things around this idea of health and wealth, it basically said that if, in order for the health indicators in the Delta to be equal to the health indicators of the other non-Delta regions, there would have to be something along the lines of oh my goodness, I'm forgetting to say, about like 400% increase in wealth in the Delta. And so in order for that to be equal, but I think the key to that is, again, creating worker-owned democracy, creating worker-owned cooperatives, with those essentially in those poor communities, essentially whose collective labor creates wealth, should be the ones capturing it. And we have a way to doing that through our food justice and food system work.
Thank you, Julian. If you were in my courtroom, boy, the court reporters' fingers would be burning. Speaking so fast there, but I'm going to turn to because I know we're wrapping up to the end of this session, which I hope for the audience has been beneficial for you. But I'm going to return to Professor Deardorff. She left us with the idea Mississippi. You've sort of tinkered with that 1890 Constitution, but that 1890 Constitution is what is governing our state. You've tinkered with it. So I want to invite you back in, Professor Deardorff, and I know Professor Williams also, to bring her back in as well. She is one of the ones, like me and others, who have represented employers and have represented employees in discrimination case about fair wages and discrimination. And so I'm gonna loop back to Professor Williams, but before we get there, I want to talk to Professor Deardorff and just you've said that 1890 Constitution is not sufficient. So what should Mississippi do, Professor Deardorff, to fix it? It's not sufficient. I think all of us would agree.
I think we all have an obligation to recognize that in a democracy, these kinds of decisions are done in our name as citizens. These policies are made ostensibly on our behalf. And when they're unjust, when they're unfair, we have an obligation to make it right. And I think that one of the things we have to see happen is not just in Mississippi, everywhere, because it's everywhere, but looking at Mississippi specifically, I just don't want to let the rest of the country off the hook. But we're talking about Mississippi today, is we have an obligation to make it right. And to me, that means not just understanding our history, but going back and looking at how our laws and our policies come out of that history. And when you look at those original documents, it's really clear why that Constitution was written. I mean, I think about one of them about convicted felon not being able to vote, that coming out of the Constitution. And there's a debate, and you can read the debate as they were determining which particular laws they were going to put in to, I mean, which crimes were going to be seen as disabling a felon from voting after they've served their time. And in that debate, it's clear they don't include murder, but they include stealing. And they say in that debate, the reason why they do that is because stealing, they think, is more likely going to be a crime committed by African Americans. And that's who they're trying to prevent from voting. It's explicit. And so, so we change it and we add murder and we take out stealing, but we don't ask, why were we preventing convicted felons from voting to begin with? Those are the discussions I think we have to be having, as to why was this policy created to begin with, and why are we retaining it today? And if it's for different reasons than why it was originally constructed, then we need to be looking at those discussions. So I think, I mean, we have these larger structures of democracy and capitalism that are operating, that are founded deeply in our racial past. But then we have these ongoing policies that we keep just assuming are just and fair, that we're not re-examining. And again, I think we have this obligation. There's this lovely quote by Hannah Arendt, which I think speaks particularly to whites, right? And she says, when you take it upon yourself as a member of the human society, the burden of what the other did, you don't accept the blame or absolve him for the blame. Rather, you take upon yourself the injustice that occurred in reality. It's a decision to be partner to the accountability, not at all a partner to the guilt. We all have to be a partner to the accountability. And we've not done that as a society. So.
Well, thanks again, getting Professor Williams back in, because a portion of her biography includes not just the criminal justice system, but employment law. And one of the questions that I asked, sort of posed to Dr. Roithmayr, was those civil rights acts all being enacted or adopted or ushered into law in the 1960s with, we believe, some hope or some promise that at some point, maybe they might not be needed anymore. I think about the debates with respect to affirmative action, for example, where in Grutter versus Bollinger, I believe it was, Justice Sandra Day O'Connor says, okay, let's allow affirmative action to go forth in its way, probably for the next 25 years. And I think that next 25 years ends in a few years now. I think like 2028 or less. So who knows what might happen then. But Professor Williams, with respect to Title VII and what it requires, and what we see coming out of cases in that aspect, that law has been on the books since 1964. Indeed, why is it that we're still seeing discrimination in the workplace on every level? Race, sex, national origin, gender, disability. Why is it that we are still grappling with these issues when there are regulations and everything else on the books and even code of ethics among people? Like I want to live next to you. I want to be with you. Could you tell us anything on that, Professor?
Well, I think a lot of that goes to the fact that they can get away with it. People, for the most part, you have to, well, one thing you have to consider is 1970, like you mentioned, 1970, 1971 was really the point at when Mississippi was really beginning to become integrated. So that's roughly only about 50 years. You would think that it was a long time ago, but it really isn't. We're still in our infancy. If you look at the four corners of the state, the culture, they're all so distinct and they're so different with regard to how the races interact, what's done, how they behave. Even now, people step off the sidewalk, still yes sir, no ma'am, won't look, depending on where you are, won't look a person of another race in the eye, won't put money in their hands if they're exchanging, if they're paying for a purchase. The culture in Mississippi is still evolving, and there are people who are, one, they don't understand the process. They don't understand what their rights are, even though there's this poster that's supposed to be put up in the workspace that says, if all of this happens, then you have a right. But if I complain and I have mouths at home that I have to feed, I'm afraid I'm going to lose my job and I won't be able to feed my family. Or because of the community that I'm in, I won't be able to get another job somewhere else. Mississippi as a state has no Department of Labor. So on a state level, we don't address those. Wrongful termination in Mississippi is limited to very specific instances of basically a criminal activity or things along that nature, but it doesn't address any of the Title VII issues. You also have to look at the fact that the size of, there are exceptions even in Title VII, whether or not you can even bring a lawsuit about being discriminated against. But one of the biggest things that I see is that people are afraid. They're afraid that if I say or I do anything, I'm gonna lose my job, I'm ostracized, I've got this label across my head, I'm gonna lose everything that I own. And then on the other side of that too is they just don't have the educational knowledge or the support system in place to pursue it. So discrimination continues because they know they hold the upper hand, they have the power, and they can control. And so it doesn't change. So until the workforce pushes back consistently, I think we will always have that problem of discrimination in the workforce. It's all about economics. A lot of it is simply about economics.
Well, thank you. We're rushing up to the end, but I'm going to give the panelists one closing thought on whatever you wish it to be. One closing point that you would like us to be, what will we remember you by in this conversation? And just one short closing thought, a minute or less. And I'm gonna go in a reverse order, a different order this time. And I'm gonna start with Professor Deardorff, and then with Julian Miller, Ms. Williams, and I'm going to allow our newfound friend from Moss Point to close us out.
I think I want to be remembered for saying we all have an obligation to engage in this work. Our democracy depends on it. Our fellow citizens' lives and livelihoods and existence depends on it. And we have let this drift for hundreds and hundreds of years, finding ways to rationalize the vast inequalities that continue on and on without finding cause to transform it. We need to find the will to do it.
Thank you so much. Julian? I know you're going to get a lot of words in your minute.
I'm going to be both brief, concise, and slow. And you're like multiple judges. I'm surprised y'all don't sit down and talk about me about that. Going too fast. I think the biggest point is to understand that you cannot have racial justice without economic justice. Ultimately, the racial disparities that we're seeing that began with the legacy of slavery, Jim Crow, was motivated economically for the goal of exploiting Black and brown bodies for the purposes of gaining wealth, exorbitant wealth, and profit and power. At the end of the day, there was a justification. There was pretty much like research. There was this thought that those who were Black and brown essentially were inferior as human beings to the white race as a means of justifying slavery morally, as a moral imperative. And we're still seeing it today. And you look at policing in itself. With policing, the idea of police forces were created to create division amongst the white and Black lower classes. So essentially that you could placate the white race with instead of paying them living wages, essentially have to feel better about themselves, feel better than Black people. And that system has essentially permeated to today and thinking about economic exploitation. So we cannot address racial disparities in every area of social good and the economy until we think about empowering those Black and brown people and all people to essentially own the wealth that they create through their labor and essentially utilize that wealth to address those disparities in other areas of social goods. And so I'm grateful to be a part of that work, grateful to have that discussion with you, and hopefully be able to work with you all collectively to doing that in Mississippi.
Thank you so much, Professor Williams.
The one thing that I constantly say is that the Constitution, even though it may not originally have been written for everybody, it is what governs this country. And that Constitution is for everybody. So if we don't stand up, use our voice, use our position to make sure that the provisions that are in that Constitution are kept secured and able to be used equally across the board for everyone, then we will never reach a point in the history of this country where there will be equal justice for everybody. So we have to use our voice and we have to stand up for that Constitution.
Thank you so much. That 14th Amendment is something else, boy, I tell you. From the ashes of this country, that 14th Amendment came out and it means something. Professor Roithmayr, I'll let you close us out. So please.
So I'll say two things. One, structural racism has to be the target. We focus a lot on intentional discrimination, but structural racism is really the place where we ought to address our energies, and there are a lot of ways of doing that. The benefit of addressing structural racism and economic justice, as Julian points out, is that you can draw in together and mobilize with poor and working class whites who will benefit from a lot of the things that I've suggested. The other thing to note, as Julian notes, is that structural racism pays. This isn't about invidious discrimination that's irrational, people not understanding and working from ignorance. The Nissan plant is making money off of exploiting people of color. White capital profits from exploiting workers of color. We have to rethink the way that we share profits in this country. We have to rethink the value of those workers who make the Nissan plant possible, those Black and brown drivers who make Uber and Lyft possible, the data labelers in India who make artificial intelligence possible. They deserve a share in the profits. They deserve a say in the company's policy. And I think focusing on these bigger picture goals are half the way of getting Mississippi to where it needs to be. And thank you so much for letting me be a part of this conversation. And I hope to work together with many of you in the weeks to come.
Thank you all. I'm going to turn it back over to the persons who's in charge with the law review, but I imagine, I know we're going into the next segment. A point of personal privilege for me is that I think they're going to let us take a 5-minute break just in case you all need to go, as they say here, powder your nose. And I imagine, please, please, please do what you can to give a round of applause to these great people who devoted their time to this segment of the thing. Please either clap, you do the Zoom clap, unmute your phone and clap, unmute your phone and clap, do whatever. But please thank these folks for such a great job.
Yes, thank you, Judge Reeves, Dr. Deardorff. Thank you, Judge Reeves, Professor Roithmayr, and Professor Miller for sharing with us. I also want to thank the participants for sharing in the chat and keeping that discussion open. Thank you, Judge McCarty. I saw you're very active in the chat. So yeah, we will take that 5-minute break and resume the panel. I have 11:04, so let's resume the panel. It might be a little, so 11:09, 11:10, okay? We'll resume the panel. So thank you all for being here, all right? So we'll see y'all in 5 minutes.
Okay.
All right, welcome back, everyone. For those who are just now joining and tuning in, thank you for supporting the Law Review, the Mississippi College Law Review, for this discussion for our symposium that we've been working on throughout this year. Be sure, if you would like, for next year, this symposium will be featured in volume 40 of the Mississippi College Law Review. So if you would like to subscribe to the Mississippi College Law Review, email lawreview@mc.edu. The first panel was incredible. And our second panel, coming up right now, is equally impressive. Judge Carlton Reeves will continue to lead our discussion today, and we are so thankful for Judge Reeves. Our managing editor, Mackenzie Ellis, will now introduce our second panel for our speakers. Mackenzie?
Yes, our first panel was great. We have 4 more excellent speakers for our second panel, including Judge Reeves, who will continue to moderate. First, we have Judge Winston Kidd. Honorable Judge Kidd has been a Hinds County Circuit Court judge since 2002. He has also supervised the Hinds County Circuit Drug Court for the past 10 years. Judge Kidd was born and raised in the state of Mississippi. He received his bachelor's degree from the University of Mississippi and his Juris Doctorate from Mississippi College School of Law in 1991. Judge Kidd was an attorney at Walker & Walker for 10 years. He is a past president of the Magnolia Bar Association, where he was also parliamentarian and Central District Director. Judge Kidd is a mentor for youth as he mentors for Big Brothers Big Sisters at Lester Elementary and students from high schools in Jackson. Next, we have Dr. Fancoise Hamlin. Dr. Hamlin is an associate professor in history and Africana studies at Brown University. Dr. Hamlin received her PhD from Yale in 2004, her master's degree from the University of London, and her bachelor's degree from the University of Essex. Dr. Hamlin teaches undergraduate and graduate classes in U.S. history, African American history, Southern history, cultural studies, and Africana studies. Dr. Hamlin is the author of Crossroads at Clarksdale, The Black Freedom Struggle in the Mississippi Delta After World War II, which was published in 2012. She is the winner of the 2012 Berkshire Conference of Women Historians Book Prize and the 2013 Lillian Smith Book Award. Before she began teaching at Brown University, Dr. Hamlin was an assistant professor at the University of Massachusetts Amherst and was a Du Bois Mandela Rodney Fellow at the University of Michigan. Next, we have attorney LaToya Jeter. Ms. Jeter is a co-founding partner of Bound, Brass, and Jeter, where she focuses her practice on personal injury and bankruptcy matters. She earned her Juris Doctorate at the University of Mississippi before clerking with the Honorable James E. Graves, Jr. while he served on the Mississippi Supreme Court. She has earned consistent recognition in the legal field and was recently named Best Bankruptcy Attorney by the Jackson Free Press Best of Jackson for 2020. Attorney Jeter is actively involved in mentoring youths within her community. Next, we have Dr. Emilye Crosby. Dr. Crosby is a professor at the State University of New York at Geneseo and has been a part of the faculty there since 1995. Her research and teaching focus on African American history and the modern civil rights movement. She has won numerous awards during her years, such as the Chancellor's Award for Teaching, the Harder Mentoring Award, the Chancellor's Award for Excellence in Faculty Service, and the President's Award for Research and Creativity. The first book she authored, A Little Taste of Freedom, won the Mecklemore Prize and received honorable mention for the Organization of American Historians Liberty Legacy Prize. Dr. Crosby was the coordinator of the Black Studies Africana program from fall 2002 until spring 2018. Dr. Crosby authored A Little Taste of Freedom, The Black Freedom Struggle in Claiborne County, Mississippi, and was an editor for Civil Rights History from the Ground Up, Local Struggles, a National Movement. I'm going to turn it back over to Judge Reeves and let him take it away. Thank you.
All right, thank you again, Mackenzie. The same rules apply here. That is, if to the extent that there are any shortcomings in this conversation, blame me. Do not blame these wonderful panelists who have devoted a significant time in preparing for this sort of discussion. And some of them were on the Zoom conversation that we had earlier. So if there's anything about that conversation through our talk, for this brief time that we have, please, you certainly would be free to do that. We have two professors here who've written about two different parts of the Mississippi Delta. As we know, for you Mississippians, Clarksdale is in the heart of the Delta, up at the northern part of the Delta. And Claiborne County is down there at the bottom of the Delta, down the southern part. And we know the unique histories that the Delta has to offer the state of Mississippi. But I'm gonna start with Professor Crosby, because I'm gonna start with the people who don't live here in Mississippi, but who've studied Mississippi, who've been here to Mississippi. But I want to start with Professor Crosby, because one of the focuses of her writing talks about ordinary people who have caused extraordinary change in our Mississippi, but not only our Mississippi, throughout the country. And just let her open up with her sort of opening up with that notion of how ordinary people have caused our country to change in the way that it has. Dr. Crosby. Unmute yourself, please. We want to hear you. We really do.
That might help, right? I just want to thank you, Judge Reeves, and everybody who's made this possible. And so if we're talking about ordinary people, who many of them I think of are actually extraordinary, but they're extraordinary because of what they've done and provide models for all of us. I would like to give a quick shout out to my teachers from the Claiborne County Public School System. I actually was introduced to the civil rights movement in part through my teachers and community leaders. And so when I began to study it in graduate school, and there was this big emphasis on, major leaders and big events, and there was a big event in Claiborne County, the Claiborne hardware decision. And I was in high school when that came down. The Supreme Court overturned a Mississippi Supreme Court decision and ruled that the NAACP and local defendants had been within their rights to use economic protest for political goals. And I went to an NAACP celebration of that Supreme Court case. And so it was a big deal, right? To have our community be in the national news and it's like major organization, major Supreme Court case. But I also understood that case through my bus driver and through my teachers who were defendants. And these were the people who made the movement. And so for me, my earliest lessons of the civil rights movement came through people that I knew of as multidimensional people, not just these kind of heroic civil rights leaders and not just national leaders like Dr. King. And, so that was kind of my introduction to the movement, and I'm grateful that I had that introduction. But I think if we think about one of the issues that confronts our country today, obviously is voting rights and this big battle over whether we're going to expand and invite all citizens to vote, or whether we're going to try to narrow voting to keep powerful, wealthy people in power. And I think that's really, in some ways, the big challenge. And one of the places where I think ordinary people have really transformed our country is with the voting rights struggle that in the heart of the Mississippi Delta. SNCC, the Student Nonviolent Coordinating Committee, a group of college students who, just even a handful said, racism, segregation, and it's what we've been talking about in the earlier panel, structural inequalities aren't okay. It has to change. I don't know what I can do, but I'm going to do whatever I can do. They dropped out of school. They gave up graduate programs. They risked their futures, and they went and lived with ordinary people in Mississippi. They recruited other Mississippians, and an organizer here or there in the toughest circumstances that you could imagine, built a movement that really, people might give credit to Dr. King and obviously rightly so, the Selma movement and many others. But I think it was really the organizing in Mississippi around voting rights that forced our country to confront the fact that so many citizens were being denied the right to vote, and forced the issue that led to the passage of the Voting Rights Act. There's lots of pieces to that, right? And lawyers played an extraordinary role in helping SNCC and other movement activists take advantage of every little crack that they could. But, you know, people like Mrs. Fannie Lou Hamer, who had been denied all but a 6th grade education in Mississippi, who worked on a plantation for 20 some years. She was a little bit younger than I am now, but, you know, a woman with a grown woman with children. And when somebody said to her, well, would you like to try to register to vote? It was a new, you know, she said it was a new idea, but she absolutely, I could see voting people out of office who weren't doing right, including people that had been part of protecting the lynchers of Emmett Till. And, you know, so she goes and tries to register to vote. That very day, she and the others run into trouble. The bus is stopped that carried them to try to register to vote. The bus driver is charged with driving a bus the wrong color, because you can't go to register to vote on a bus that looks like a school bus. You know, any excuse will do. There was a scholar I read who said that the law in Mississippi at that time was about upholding white supremacy. And, you know, Mrs. Hamer basically just said, I'm going to pursue this whatever it takes. And she paid a price, as did others. But she's one name, and a name that many people know, but there were many people like her who said, I'm going to give this a try. And at that point, there was nothing to suggest they would be successful, and everything to suggest that the powerful people in the state of Mississippi would be able to match everything that they could bring and more. But they were successful, and they were successful organizing person by person, building a movement, and working in some cases with the Justice Department, not necessarily with the FBI, was not always very helpful, but there was some help from the Justice Department. You know, the case US versus Mississippi, I don't know how much you look at that in law school, or if you do at all, but it was an important lesson for the Justice Department attorneys and how difficult it was going to be to use the existing laws to try to bring the franchise to African Americans in Mississippi on any kind of sustained way. And so it's also kind of an example for us that while we can use the laws, we have to use the laws, they are not enough. That you have to have people insisting on enforcement and insisting on expanding them to you know, so if the 1957 Civil Rights Act does not have enough in it to ensure, you know, voting rights, then we're going to create a mass movement and, you know, get rid of the impediments. And, you know, I think some people consider the Voting Rights Act one of the most important and significant and effective pieces of legislation in our country, you know, until it was gutted, right, recently, and which is kind of led us to this place where we are really in the midst of a fierce battle where all these states are implementing laws to restrict voting rights. And there's some legislation before Congress to try to help with that, and people organizing on the ground again. So I should stop, but before I go on too long, but I mean, I think that you're absolutely right that we can't understand the movement and our country and much of what's positive about it if we don't really think about the people that are everyday people in our lives who make a decision to stand up and work for something. It's for themselves, for their children, for their family, for their community, but it's also for our country. And it's made a big difference. And so I think about, I guess I'll just say one more thing, is that one of the things that I've learned, I think, from studying the movement is that laws, Mississippi needed federal intervention, absolutely needed federal intervention. But if Mississippi just sits back and waits on federal intervention, nothing will ever happen. So ordinary, everyday, and in Mississippi and in much of the country, to be honest, African Americans lead the way on justice movements for all of us. And that's what happened with the civil rights movement. But African Americans in Mississippi with a few allies insisted on voting rights. And that's really, that organizing is what led to the Voting Rights Act. It wasn't led from the top down.
Thank you, Professor Crosby. You reminded me of a point where you're talking about ordinary people and young people. We know SNCC, the Freedom Riders. One of the points that I came to appreciate in clerking for Justice Anderson when he gave talks and speeches and stuff, he always mentioned Diane Nash and Bob Moses. And he always talked about these kids coming to Mississippi. They were already registered to vote from wherever they came from, but they came here to Mississippi to help empower people here. And it was so incredibly powerful and important that these were, number one, these were children.
Mm-hmm.
They were 18, 19, 20, 21 years old. I mean, they were in college. They were younger than all of us who are on this call are, for the most part, because most of you are in law school and older. These are young people who gave up, who sacrificed part of their, I guess I say sacrifice, but they embedded their educational foundation to come here to help in the struggle. And I'm going to bring in Professor Hamlin, because she's written extensively, again, on that northern part of the Delta, that Mississippi Delta, the home of the blues area, and Clarksdale. And I just want to let her, invite her into the conversation in her own way, talking about issues that she knows that persisted then, as well as issues from her studies and stuff that still persist in this decade. Professor Hamlin, thank you for joining us.
Thank you for having me. And I agree with everything that Dr. Crosby said. She's totally on the nail with that. I think also what I found in Clarksdale was thinking about local activists through the NAACP, right? So when I think about the civil rights movement, I've always thought about it as a mass of movements. So Claiborne County had its own movement based on the local people there, the needs of the people there. Greenwood had its own movement, Jackson had its own movement. They were all connected by people who moved through organizations and worked together and passed ideas. And the students were a lot of the connections too, because they would travel through, but each locale had their own set of issues. And Clarksdale was one of them. And Clarksdale has had a sort of a stronger network of local people. Aaron Henry is the home place of Aaron Henry. You know, and he ended up being one of the state NAACP presidents, and sort of a very large state figure. But it did keep sort of the NAACP very strongly embedded into Clarksdale. So there were fewer students there in that county. But they were all sort of talking to each other across organizations as well. And sort of the thinking about voting, there was the Mississippi Voters League in the 40s and the 50s that were, and the Regional Council for Negro Leadership, right, coming out of Mount Bayou and Cleveland. So there was a strong Black activist foundation that encouraged and supported the young people when they did come in and help them, give them a foundation and safety to come in and do their work too. So Professor Crosby and I, our histories all really work together well, and I actually often teach her work because of that, to kind of really show how different they are, but yet how similar they are in some ways. And we're talking about the same state, right? To try and break free from this idea that there can only be one way of doing organizing, there can only be one movement, that there's a one size fits all for the nation, when that's not true. I think we really do have to drill down into local needs. And I think that's why, you know, Stacey Abrams was so, and her cohort was so successful in Georgia, right? Really specifically catered to local needs. back to Clarksdale. You asked sort of what are the issues that still persist. I was there as an exchange student in the early 90s and went back and wrote a book. So I lived there for a year. I got to meet a lot of folks and then came to grad school in the US and have continued a relationship in Clarksdale that I treasure. But one thing I have seen and that has persisted and probably gotten worse is that there's an underemployment. The people are underemployed. There's not enough industry to sustain those that are not in the service industry or the tourism industry. And again, tourism in Clarksdale revolves around the blues. It's getting better, right? There's this sort of now, I think the state has realized that civil rights is actually a moneymaker for the state. Money, civil rights history. So now there is more sort of money towards markers and plaques and stuff. But again, there's underemployment of local people, right? There's a lot of time they're bringing people into the state to do that. And so there's still sort of the balance of power and who owns that history and that knowledge is still it's not up for grabs, but it's still an issue. So with the underemployment, you find that there's been a brain drain. Those who grew up in Clarksdale and went to school in Clarksdale, there are very few professionals there who had grown up in Clarksdale. They've moved in. Most of the young people have moved out once they go to college and move further if that's what they're going to do. And those who do stay are traveling to Tunica, to the casinos to work, right? So there's just not enough local investment to hire folks and keep people in Clarksdale. There's been a lot of gentrification in Clarksdale, downtown. So it looks very lovely, but it's still catering towards a very specific population and the vibrant tourist industry. Not necessarily the community. So I asked folks who I grew up, I went to school with, and they would say that they don't go downtown or they've never been to these restaurants, those kind of things. But also what I'm seeing is that there is while there's this sort of an effort to embrace some of this history, there's still a suppression of it. There's a way in which I see the Chamber of Commerce particularly trying to control the narrative so that Clarksdale doesn't look too bad because it's bad for business. So initially, for instance, when my book came out, the Chamber of Commerce refused to have anything to do with it. It wasn't sold in Clarksdale for the first 7 years because apparently, and I was told this, that I've written a negative book about Clarksdale, like I made it up, right? But that's a real problem. And now, because I have, connections there and I talk to folks and I'm there all the time, it's now being sold, but it was just met with resistance. So that was just really telling to me as well about, again, thinking about the narrative and the balance of power and this wanting to embrace history, but only history that they would, that could be marketable. I'll stop there, but I could keep going for a long time.
Well, no, thank you. Mississippi, you were accused of revisionism, but we know Mississippi has engaged in that a whole lot. We could talk about the Confederate flag all day, for example, and the United Daughters of the Confederacy and all of that whole impetus to sort of change the narrative. But that's, again, I told you in the first panel, race in every aspect of our lives. It cannot be removed from any conversation when we're talking about Mississippi. And I'm going to invite Judge Kidd into the thing because we talked in the last segment, we talked about housing and employment. Now, Dr. Crosby has introduced the whole power of the vote and how that process, Dr. Deardorff talked about that 1890 Constitution. We talked about all that and criminal justice with Dr. Williams. But the simple question, Judge Kidd, who's been a judge now since 2002, roughly 20 years on the bench here in Hinds County. And I'm just going to ask him the basic question about what he has witnessed, or if he's witnessed issues with Mississippi's struggle to, I guess I've sort of defined the question, with Mississippi making access to justice available to all of its citizens. Judge Kidd.
All right, thank you, Judge Reeves. Access to justice is obviously very important to the orderly administration of justice. That is what is so great about our American justice system. All individuals must be ensured of an equal access to justice. I've witnessed a number of individuals who appear in court without a lawyer, and that makes access very difficult. When we talk about access, we have to separate the criminal cases from the civil cases. Quite obviously, in criminal cases, an individual can be appointed an attorney if they cannot afford an attorney. In criminal cases, in a limited amount of situations, the individual will refuse a court-appointed attorney and will attempt to represent themselves. And obviously that can make access to justice very difficult for a pro se criminal defendant. In terms of civil cases, our American justice system generally provides that each party must pay for their own attorney. And of course, there are some exceptions in civil rights cases where the fees for the attorney for the prevailing party are paid by the government. And usually these are cases which are filed in federal court. One thing that I see all the time is where individuals have a valid injury or a valid claim for court, but they're unable to get a pro bono attorney, or they're unable to get someone to represent them in court. And they have to come to court to pursue their case on a pro se basis. And obviously, pro se litigants will have a difficult time understanding court rules and a hard time receiving justice. So that can be very difficult if you're pro se in terms of a civil case. Access, again, is very important. Individuals feel like they have access to justice when they are treated fairly. One thing that I tell my pretrial practice students on the very first day of class is that when you go to court representing your client in an attempt to receive justice, you already know that it is very unlikely that both sides will win. Somebody has to lose. The question is whether you were treated with fairness inside of the courtroom, whether you had a right to present your case in an equal and fair manner. And then you can be assured of the access to justice. So all of that will come into play when we talk about access to justice. You can go to court, you have a judge that's unfair, not treated fairly in a courtroom. That's not access to justice. The fact that you are inside of a courtroom does not define access to justice. Whether you are treated fairly inside of the courtroom and whether you were given a right to present your case in an equal and fair manner.
Thank you, Judge Kidd. I'm going to bring in LaToya Jeter into the conversation, who is now the president of the Magnolia Bar Association, a distinguished group that I once was president of, and Judge Kidd, and I think there are some other members. Obviously, there are other members of the Magnolia Bar who are on this call. But Ms. Jeter is far younger than, Judge Kidd and I are contemporaries, having navigated this court since the late 1980s. But LaToya sort of represents this next generation for us. And LaToya, I'll just ask you, in your civil rights practice, what, if any, are the common things the issues that you are seeing? And then we're going to talk about your bankruptcy practice too, but tell me a little bit, what are the issues that you see persistent in your civil rights practice?
Well, Judge, first of all, I want to thank everyone for having the opportunity to be here, but I think the issues that we see are very similar to what everybody's been talking about. We handle a lot of employment discrimination cases where people have been either wrongfully terminated or didn't get hired for a job based on their race. And one of the common things in these cases is the issue of not what really happened, because for most times people can really say they've been discriminated based on their race, their gender, one of those discriminatory issues, but the issue is what can be proved, and it's often difficult to do that because, as people have said today on the earlier panel, one of the biggest things is about establishing that proof, and normally that occurs through witnesses, and witnesses are not likely, and for the most part, it's been my experience, it's a very difficult situation to get witnesses to want to cooperate and to tell what they've witnessed and what they've seen. In addition to that, some of the other things is that racism now, I see a lot of it is more so unconscious. There are overt actions that take place, but a lot of the issues that we get is mostly unconscious efforts that have occurred. And so it's difficult to establish and to make a case for those claims. Some of the other issues that we see a lot, and I think it's so timely as to what's going on in our climate right now, as we see with the George, the trial that is taking place in regards to the death of George Floyd. Police misconduct. There's so much going on with officers essentially being shielded from qualified immunity. And I think, Your Honor, you wrote a very timely opinion that has received so much national, attention about the issue of qualified immunity and how officers are shielded from this, even though in most aspects they're engaging in some constitutional violation of people's rights. But it's happening because they're being shielded by the law, because there hasn't been any clearly established conduct things that, where there's been law that specifically says that an officer has engaged in this prior conduct and it was illegal conduct. So I think those are some of the issues that we see quite frequently.
Thank you, LaToya. I'm going to go back around the table with my second round of questions, beginning with Dr. Crosby. And your book, Little Taste of Freedom, the Black Freedom Struggle in Cleveland County. You focused in on ordinary people / extraordinary people. You talked about the Voting Rights Act, and then you've talked about what we are seeing today. And I think about the Shelby County decision, where Chief Justice Roberts, there's a famous line in that case where he says the country has changed. And that was part of the justification in rationalizing that somehow Section 5 was no longer necessary in its current iteration. I guess that's one place. So in looking at your Cleveland County book, it talked about Southern freedom struggle and all that. And I'm going to just ask you the question. Has it changed? The country, has the South changed? Has Cleveland County changed? If not, why do you say that? If it has changed, tell me, why do you believe it's changed? And what does that have to say about the current struggle that we're seeing with respect to barriers that are being implemented? Well, in the views of some, barriers, in the views of others, taking away barriers to right to vote. So I'll let you take that, unpack all of that any way you want to, Professor Crosby.
There's a lot there, and it's also so important, right? Yes, absolutely, things have changed, and yes, absolutely, we're struggling against the same issues, around the same issues of who has power and how they use it. I think in the earlier panel, people talked about the issues of, structural racism and economics. And I think those are at the heart of the challenges we still face. Criminal justice is clearly a huge issue. I know that there's lots of opinions about the language Michelle Alexander uses with the new Jim Crow. But one of the things I've been thinking about lately with police reform and the defund the police movement and some of these kinds of issues is, so in Rochester, New York, where I live now, we've been in the national news with our police force recently, where a 9-year-old girl, for example, was pepper sprayed after she was handcuffed in a police car. And an officer said to her, "If you don't shut up, I'm gonna pepper spray you in the eyes." And then another one says, "You're acting like a child." And the only person in there in this whole context with any sense was the child, who said, "I am a child." And I think she was the only one acting age appropriately. Obviously she was struggling, her family was struggling, and they pepper sprayed her in the eye after threatening her. She's handcuffed in a police car, 9. But part of what that made me think about was how whites felt that they could control African Americans pre-civil rights movement. And one of the questions that we were asked was about the importance of movements in local communities. And in Greenwood and other parts of Mississippi, the organizing led to the Voting Rights Act. In Claiborne County, the Voting Rights Act really kicked off the local movement. Angela's uncle stepped forward, Reverend Dorsey, when it was very dangerous to do so. He took on the public leadership of the NAACP. Vernon Dahmer had just been murdered in Hattiesburg. This was not an easy thing to do. He stepped forward. But anyway, Claiborne County is 80% African American. And at that point, only a handful of African Americans were registered to vote. With the passage of the Voting Rights Act, the federal law made it much easier. And so within 10 years, there were more African Americans elected to countywide office than there had been registered to vote before the Voting Rights Act. So in that sense, it's transformative. It's absolutely transformative. But some of what was important was happening on the streets, as African Americans said, you don't get to say whether I walk on the sidewalk or whether, I can look you in the eye. And one of the big things that happened in Claiborne County was a boycott. African Americans said, yes, we are going to change things through the vote, but we don't want to wait for that. There are things that need to happen right now. There had been no desegregation as a result of the Civil Rights Act of '64 in Claiborne County. It was just ignored. And I think that's another thing we see, that until there's a movement in a lot of these little towns and counties, there's no implementation or enforcement of these major laws. And so African Americans in Claiborne County issued a set of demands, 20-some demands. Most of them were basic things like courtesy titles, hiring people, treating people with respect, implementing the laws that had been passed. White officials and merchants said, what are we going to do? We are going to do nothing. We are not going to make no concessions. And so African Americans initiated a boycott, which was devastating to white merchants because that's who their customers were. But that boycott eventually leads to the merchants filing suit in 1969, Claiborne Hardware versus NAACP that I mentioned earlier. And when you look at the testimony of that case, you really see how whites assumed that they owned and controlled public space. It was there for their convenience. They didn't think African Americans should be able to walk the streets. And so they described all kinds of behavior that they considered evidence of a conspiracy and violence that's really basically things that are covered by the First Amendment, the right to picket, the right to express yourself, the right to actually walk on a street. And so in Claiborne County, the Voting Rights Act and getting people elected to office was important, but so was African Americans saying we are going to claim public space and we are going to, but if I have a few more minutes, I want to talk a little bit about what comes out of those elections. So in 1975, one of the important elections in Claiborne County was Evan Doss Jr. He was elected tax assessor. And he was fought every step of the way. So he campaigned with a group of organizers. It was a very well organized campaign. And they said, we are going to equalize and have a more just tax system. And we need that so that we can actually implement movement goals as a result of having African Americans elected to office and, you know, having a majority on the Board of Supervisors and so on. The Board of Supervisors immediately, there was still a majority. Was it still 75? Yeah, 70. When he was first elected, there was still a majority white Board of Supervisors. That was in 71, actually. So they immediately cut his budget, but he and a bunch of volunteers, they completely survey every property in the county, and they find the kinds of inequality that you just mentioned in the previous panel about how houses were assessed. In this case, properties owned by wealthy whites were assessed well below value for tax purposes. And, you know, so a plantation might be assessed at the same rate as a home without running water, and paying the same level of taxes, actually. And so Evan Doss and his allies are trying to come up with an appropriate assessment without having a budget, without being able to hire staff, and with, you know, sort of frivolous lawsuits filed against him. The Lawyers Committee for Civil Rights under Law, the Southern Land Fund, Jesse Morris recently passed away. He was very involved in this. And they actually really pushed this. They got some changes at the state level in tax policy. But I bring this up because it's an example of the kinds of tangible changes that can come with elections. But it's also an example of the extent to which whites retained power, economic power, political power at the state level to resist this important change. And so this is part of why we still need the federal government to implement the 14th Amendment and to really, but obviously we can't just rely on the federal government to do that. So your question, you know, has anything changed? What has changed? You know, your presence on the federal judiciary, I think, is a big difference than Justice Harold Cox, I think, was one of your predecessors. You know, that's an important change. There are more tools for the struggle, but I think that the economics, you know, have not been addressed, and we need massive reparations. Our country needs to address, you know, not just the legacy of slavery, but the legacy of Jim Crow and everything that's come since. And so that's a whole nother story, but I hope I've at least given a little taste of a little piece of that question from the perspective of Claiborne County.
Yeah, you certainly have, and I appreciate that. And, you know, we've become so separated from prior generations because we've only, particularly, and I'm speaking to the young people on this thing, you know, they've lived in a Mississippi from the viewpoint of a Mississippi that's from 1990s forward, or even 2000, because they're 20 years old. They have seen and experienced, I think, and I hope, a much different Mississippi than I did in the 1970s, than my parents did in the 1940s and 50s. But I'm gonna ask Professor Hamlin to come back in to pick up where Professor Crosby left off, because, you know, we do want to figure out a way to at least make this place more perfect and to have some sort of hope and some desire, if you will, to fix systemic issues and stuff. But do you have any ideas, Professor Hamlin, on how Mississippi might be able to fix these issues that we've sort of talked about in these two different panels that persist, that I think that we agree that to some degree still persist with and further expand equality, I guess, and expand, you know, make sure that freedom, access to freedom is granted to all of its citizens?
Yeah, I'm going to say something really controversial, and you can blame it on the fact that I'm not born in this country. The Constitution's the problem. You know, if you think about when it was created, by whom it was created, and for whom it was created, that foundation in itself, if everything in the US is sort of springs from that foundation, you kind of have to like change the Constitution completely, which, you know, which is revolutionary and sort of, so I'm going to step away from the lawyers and the judges in the room and to say, you know, but like a real change, that's the way it's got to be. However, so I thought about this question, and Frederick Douglass came to mind, right? Power concedes nothing without a demand. It never did, and it never will. Find out just what any people will quietly submit to, and you found out the exact measure of injustice and wrong, which will be imposed upon them, and those will continue until they are resisted, either with words or blows, or with both. He wrote that in 1857. It could have been written yesterday, right? And that's the problem, right? So when we're thinking about progress and change and how we can think about success, I always go back to these sort of what our elders and our ancestors have said and see, have we moved from that? Or is this still relevant? And unfortunately it is, right? So basically you can't rely on the system to teach people how to change the system. That's just not going to work. That's what Frederick Douglass was saying in 1857, right? And I do think that sort of movement activists, as they get older, right, they don't no longer have that youthful activism and youthful energy. They get tired, and they stop. You know, you get some gains, and you stop demanding things, and you stop fighting, and you become, you know, you start acquiring things. Risks start happening, personal risks, and no one. And that it is harder to pass on the baton, and it's harder to for younger people to pick up the baton, right? I know from a lot of activists I've spoken to, they felt that they wanted that to shield their children from what they had experienced, right? And sort of have the children enjoy some of the sort of gains that they had, you know, and as parents, that's what we do, right? We want to raise, yeah, I'm looking at these amazing quotes coming up. Yes, all of that. And all of these sort of ideas of how we want to raise our children so that they don't have to struggle the way we did. But in doing that, we're not teaching them tools. We're not, you know, and so I think that's what you were saying with this generational shift that grew up with Obama thinking that was normal. When all of us who knew before that were like, oh no, this is a blip. It's going to go bad. It's going to go bad real quick, real fast. And it did for a whole 4 years, right? And it hasn't stopped. So education is the key. We have to educate our young people across the board about the past in truthful, real ways, right? Racism is taught. So we have to unteach it. And it has to start in the schools. So I still think the schools and the curriculum is the sort of the main battleground. And again, coming from England, schools, the way schools are funded here compared to there, that's another problem, right? Sort of this idea of schools are funded based on local tax revenues. And then we see how that kind of trickles down and doesn't, you know, and again, unless you change that system completely, it's not going, the education system is always going to be the way it is in just different iterations of bad. So, you know, when I think about that, what worked in the past was this idea of freedom schools and self-education. Communities need to teach you can't rely on the school system to teach your kids anything, quite frankly. I find that, you know, by the time I get them in college, I'm having to unteach a whole bunch of stuff in order to get them to think critically, because they were fed a whole bunch of stuff that is designed to keep them as cogs in the system. So, you know, that's where I think a lot of activism needs to go into the schools, but also like thinking about the freedom schools that were run in, you know, back in the day that actually taught young people civics, Black history, but now we can include other histories in that, things that are not being taught in the schools because Common Core really does hamstring a lot of what the teachers can do, right, in classes. So they're taught to a test, but the test in itself is problematic. So we can talk about, the problems in education, but the idea of, I think for me, we need to just keep working with educating all children. So not just African-American children, but all children, right? And having sort of this sort of way in which we need to put civics and history back in the schools, because I see that being pulled out. And I think for young folks, trying to get them to understand why it's important to vote. It really breaks my heart when I see young people who are newly registered voters who are like, oh, my vote doesn't count. You're like, did you just see Georgia? I mean, really? No, every vote counts. So trying to, and especially up here in the Northeast, they think it doesn't count because it's all blue. It's not, it's going purple, right? So it's like, it's really important to, teach that as well, and that comes with the teaching of the education and what have you. And I wrote my book in part because the folks I grew up with didn't know their own history in Clarksdale. They didn't know that they were living among heroes. They didn't know that their grandmother was a freedom fighter. They didn't know, and that was like, really, you don't know this? You don't know about Erin Henry? Like, so that became really obvious to me that education, it will help with the employment issue. I don't know, it's just, that's how, when I think about sort of your question, that's sort of thinking about Frederick Douglass, but then also how education is completely tied into that. And part of the fix has to be knowledge, in order for folks to understand what's at stake.
Thank you so much. Again, the Law Review is putting on this program. So it's wonderful that we can engage in this discussion. And I can always say that was academic freedom. I was just sitting there listening, because you're talking about
the disclaimer earlier.
but it's so wonderful to hear, and I see what others have been placing in the chat. But I'm gonna go back to Judge Kidd, because we were talking about access to justice, and he was primarily focused in on civil justice. Ms. Williams earlier was talking about the criminal justice system and in Mississippi, and how it has completely failed those persons who have, as a judge, again, our system loves the idea of finality, Professor Hamlin. We don't like to unwind what a jury does, because there are rules in place. Professor Kapenda knows, as having clerked on the Court of Appeal, your standard of review, how you review decisions that have been made. We lock in whatever the process was in the beginning, and it's sort of hard to unwind the thing. So when courts make it, like the Mississippi Supreme Court, when it makes a decision, it becomes literally final for all intents and purposes, even though it may be a wrong decision. So Judge Kidd, I want to get you back in here, because one of the novelties that Hinds County, along with other circuit courts, have done to sort of, I guess it's to sort of help in some way. And I know over the last several years, you've been the lead person in the circuit court here in Hinds County over the drug court program. If you will, could you describe your drug court program, how it compares to others that you know of across the state, and what, if any, impact do you believe your program might have as far as access to justice? And it goes back to, I think, the point that I made with the earlier panel, a powerful tool, and I say the most powerful tool in the hands of a prosecutor, is the power of discretion. And in many of these jurisdictions, I think, for those persons who are eligible to even opt in or to be made for the drug court system to be made available to, starts with the prosecutor. But if you will, just tell us about your program.
Well, okay, thank you, Judge Reeves. That's a very loaded question, but I'll attempt to answer it. One of my greatest things that I do about being a circuit judge is presiding over the Hinds County Circuit Drug Court Program. Drug court has been in place here in Mississippi for over 20 years. I have presided over our program here in Hinds County for 10 years. We monitor approximately 175 to 200 participants a year in our program. Drug court is a judicially monitored program for criminal defendants whose crimes are deeply rooted in their drug addiction. The crime must not be a crime of violence. From the onset, let me tell you what drug court is not. It is not merely a slap on the wrist. Participants are required to pay restitution to their victims. They are required to work. They are regularly drug tested to keep them clean. They are to receive their GED if they don't already have a high school diploma. So in our drug court program, these nonviolent defendants are held accountable for their actions. What we do to transform the life of a criminal defendant in drug court can save that defendant's life, as well as keep the family unit intact. You know, I spend a lot of time dealing with drug court in addition to my regular circuit court duties. I think it's very important that we treat individuals with an addiction like they have a medical issue. And I know that's a difficult issue for some to deal with, but if you have an addiction and you committed that crime solely because of your addiction, then we should perhaps spend more time and more money in addressing that addiction. What I have found is that if we place individuals with the addiction in drug court, then we save costs to the state where the incarceration costs are decreased. We save the family unit. We get the person back into society where they can work and be drug-free. So there's no question that drug court has helped individuals with addiction problems. On the other hand, drug courts are not perfect. We strive to make them better every day. Questions arise as to how can we make drug court available to everyone in an equal and fair manner. Drug use has been around for a long time in many communities, and it has ruined many lives and destroyed communities. So when a crime is committed, usually the first question that the lawyers or the prosecutors might ask is if the defendant has a drug problem. And if so, let's get them some help. Unfortunately, in our country, we value some lives more than we do others. We see some as worthy of helping, and we see others as not so worthy. We excuse the behavior of some, and we lock up others for long periods of time. Far too often, if you are African American and commit a crime because of your drug addiction, you are presumed to be an ordinary criminal instead of a drug addict. Our history shows that it is very difficult for society to view an African American male as a drug addict instead of an ordinary criminal. It's very difficult, especially if the prosecutor, defense lawyer, and the judge are all Caucasian. And you know, we have to discuss the issue that we're oftentimes uncomfortable discussing, and that's racial bias, implicit racial biases. Biases that individuals will have that they're not even aware of. Many are not knowledgeable about the history of racial oppression in this country. And even in our state, many try to fool themselves by saying that everything is equal now, but we all know that everything is not equal. I assume that's why the Law Review is having this symposium, so that we can bring awareness to the inequality that exists. So in Hinds County, in our drug court program, many of the judges know what it's like to live as an African American in this country. And we know the history. So it is not difficult for us to realize how important fairness and inclusion is as it relates to drug court. On the other hand, in some counties, judges, prosecutors, and the legal community at large perhaps must first educate themselves and painfully examine their own racial biases, because it exists. It exists in every aspect of drug court. And until those issues are examined, then you will not include everybody into the drug court program. People will be excluded. Individuals who use drugs, charged with a crime, if you're African American male, you might not be offered drug court. You might be offered 5 to 10 years in jail. I submit that is not fair. If there is an addiction with a nonviolent crime, the drug courts need to be made available to everyone in an equal and fair manner. And again, we strive to make drug court better each and every day, but with implicit bias, that can be very difficult. And where everyone involved in this African American male's case, everyone involved is Caucasian. And they might view that criminal defendant as a drug dealer only, even though he's had an addiction for 5 to 10 years. So we have issues that we need to address with respect to drug court throughout the state. But again, here in my drug court, here in Hinds County, we've overcome those issues, and we serve individuals regardless of race. If you have an addiction problem, we admit you into drug court and we deal with those issues to make you a better individual, to make you a productive member of society. And hopefully in the future that we can do that statewide. Thank you.
Yeah, no, thank you, Judge Kidd. I mean, you've seen literally hundreds of people who come through the process, hundreds of people who are eligible and can't even get to the process. So I really, really do thank you for those comments. I do want to underscore one thing that you said a couple of different times is implicit bias. You mentioned implicit. That's bias that we don't recognize that we have. But I think certainly you and I can agree that in our system, because we are made up of individuals who control and are over the system, there is indeed explicit bias from time to time. And I'll just give you but one example. Curtis Flowers case, explicitly going out striking Black folk from juries. And again, I tell you how we embrace finality with our state Supreme Court on those numbers of the times, affirming that conduct, reversed it sometimes, affirmed that conduct over the last couple of times. Again, how do sort of embracing finality. That case went up and down how many different times? But each time, the forces of our state government came forward to protect the prosecutor in that case, to defend that action in that case, argued at the state U.S. Supreme Court that what he did was not unconstitutional. Again, so sometimes it is implicit, but sometimes it is so explicit. I'm going to invite you back in, Ms. LaToya, Ms. Jeter, Madam President. And I don't, we haven't talked at all about how, if any, COVID has impacted how you do your business today. But also I do know that when Mackenzie, I believe it was introducing you, she talked about all that you have been doing with respect to the youth in our community. And I want to ask you to touch on their access that they might have that may or may not be different from others, but also talk to us with your robust bankruptcy practice, how that, how, if any way, is that involved with the conversation that we've been engaged in today?
But Judge, I think from my mentorship experiences, honestly, I'll tell people I'm a first generation lawyer. So when I grew up, I didn't know any lawyers. In fact, I know more people who were probably having problems with the law than were actually fixing the law. So in my mentorship, I think charity always begins at home. I always feel like before you can go out into the community, you got to work on what's going on around you more so. And what I've seen is that most youth, I think we've said it here, especially African-American youth, they're trained initially on from the beginning that the odds are stacked against them and that they're not going to be able to be successful. It's taught. And I don't know, over the years, I've tried to, examine, is this something that is explicit or implicit? But I think it starts in schools. I think for so many youth, they're already, by the time they get to kindergarten, they've had issues at home. They're not getting the proper foundation so that they can learn to be great readers. In the society that we're in now, I think the word is used that critical thinkers. And it's kind of hard to think critically if you haven't got the basics so that you can learn to read. So it starts with the problems that we see in the family nest, the family home, where they're not given those opportunities. So by the time they get to middle school and high school, yes, I've started to have problems in other aspects of my life, but it stemmed from the basic lack of, I would say, just didn't get the basic foundations as far as educational opportunities, because we're not given equal opportunities. And I understand that, yes, great strides have been made from where we've come from, but there's still so much work to be done, because there is a large gap between the rich and the poor as far as educational opportunities for the youth. And so when you see that, it's like, how do we fix it? What do we do? For so many of us, it all starts with self-esteem. If I don't believe and I don't see other people around me that are doing it, that's going to be hard for me to believe that I can achieve. We need to have people to reach back into communities, to spend time with the youth, give them the opportunities that they need so that they can grow and so that they can learn. And as it relates to my practice, I guess in general, one of the things with bankruptcy, I think it touches on one of the touchy issues with race is about classism as well. It's not just about the race, but it's also about the money. Without the money, you can't afford the opportunities that some of your other colleagues in white America has. And one of the things about bankruptcy, I think I was drawn to this area of practice because in our communities, it's considered to be taboo. It's something that you normally don't do. It's considered to be not a good thing that you can pay your debt, but we all know from a legal standpoint, it's okay to ask for a fresh start. And we should utilize that when it's, when it's appropriate in our lives. But for most of us, we've been taught to struggle through and to take out of our retirement, to pay bills off instead of using the opportunity to file bankruptcy. So I think overall, what I would say about these things is that race is one of those issues that we encounter, as you said, every day, and we're going to have to deal with it, and we're continually deal with it. But when you couple that with the lack of opportunities and the financial resources, it becomes even more difficult. And it's issues that we have to look at as a whole.
Well, thank you. I'm going to do something a bit different, and I'm going to go back to Judge Kidd right now, because he's talked about the drug court. He talked about access to justice, and I'm going to get Professors Hamlin and Crosby back in after Judge Kidd, but I wanted to ask him, what we've seen over the last several years is an incarceration crisis. Dr. Crosby talked about Michelle Alexander's book, for example, The New Jim Crow. But I guess from the point of view of having sat here in Hinds County as a circuit judge, which has jurisdiction over criminal cases, I guess, do you see that there is an incarceration crisis here in Mississippi? And what, if any, sort of reform that you believe, or any reform that might be needed with respect to our criminal justice system? And I know that could take you from now until the end of the week, but just help us out.
Okay. Well, when we talk about reform, we've had a lot of discussion about that in the past few years. And usually when we hear the discussion, we think of ways that how we could reform our criminal justice system. We've had a lot of talk about it, but not a whole lot of action about reforming our system. So we have to be serious about reforming our criminal justice system. So if I had to, if I was someone who could really make changes, if a legislator or make the laws, there are probably a few changes I would make. I'll give you one example. When I first got on the bench almost 20 years ago, and I'd never practiced or handled any criminal cases. So the criminal felony cases were new to me. And when I had to sentence individuals, for example, house burglary, and when you look at the range of sentence that we have, you can get 3 to 25 years for house burglary. So I might give you 3 years and suspend 3 years and put you on probation if you are a first-time offender. Another judge looking at these same facts, the same crime, same first-time offender might give you 10 years with nothing suspended. So we have to figure out ways that we could have some consistency. It shouldn't matter, are you going in front of Judge Kidd or are you going in front of another judge? There should be some consistency. The same crime, first-time offender, again, Judge Kidd might give you probation. Some other judge might give you a lot of jail time. There's no fairness in that type of sentence. So that has attributed a lot to our prisons just being overcrowded, where you have a number of people there, quite frankly, who should not be there. And I've sent a lot of people to jail. I've sent a whole lot of people to jail. And one thing that makes my job a lot busier for me is that I really concentrate on a sentence. Before I decide to send someone to jail, I spend a lot of time dealing with that issue. Now, on the other hand, I could look at the law, 3 to 25, give you 3. So those are issues which have caused our prisons to be overcrowded. I'm not sure how we deal with those issues, but I know for a start, what I talked about earlier, our drug court program, getting people in a program such as that or some other type of alternative sentence could help alleviate some of the crowding. In terms of implicit bias, or as Judge Reeves said, explicit bias, we got to treat individuals as humans. We got to treat all individuals as humans. The preamble to the Constitution states we the people. That means everybody. It doesn't say some people. It means we the people. And we got to treat everybody as though they fall within that term of we the people. The fact that you've been charged or convicted, we still have to treat individuals as human. And oftentimes individuals are not treated as humans. So a lot of issues exist as to, are we getting individuals help they need? I know we talked about drug addiction, but we have mental illness. We have a number of individuals who are, quite frankly, mentally ill, charged with felonies, and I see it all the time. I send them to the state hospital for a mental evaluation, and he comes back competent for trial. Oftentimes, that's not a correct assessment. You have individuals who can't explain what they're charged with, don't know what they're doing in jail, mental illness. So we have a lot of issues that we need to deal with. And finally, let me say that we have to question the types of sentences that we give. You know, we have to say, is this a crime of violence? Is it a nonviolent crime? And we have to ask ourselves, what is the value in an extraordinary lengthy sentence for a nonviolent crime for a person who is an addict or for a person who has some type of mental illness? I would suggest there's no value in that type of sentence. So when we talk about criminal justice reform, we have to look at all of these issues, whether or not judges are being consistent, whether or not the person has to hope and pray that they go in front of a judge that will take into consideration whether or not they're an addict or whether or not they're mentally ill, or whether or not we go in front of a judge who will say, you're charged with this crime, the law says I give you this amount of jail time. So those are all issues that we need to address when we talk about real criminal justice reform.
Thank you, Judge Kidd. And I know we're getting to the end of our program, so I'm going to ask each of the remaining three people this particular question. I'm gonna start with Ms. Jeter. But first of all, I want to, again, thank the Law Review for this dynamic conversation. I want to thank Professor Kapenda because she writes about these issues. She teaches these issues. She goes to conferences and discusses these issues. And I believe, I have not spoken to her or the other panelists who've been involved. I believe that they have come into contact with one another through engaging in these conversations at these conferences. And Professor Kapenda has brought this back. These extraordinary group of young women, that's special. These extraordinary group of scholars, these young women who have talked about these things today and have opened up our eyes to all of this. And as you know, there was just Judge Kidd, myself, and Julian today. And of course, Jade was not here. But this is the powerful discussion of women having this conversation, leading this conversation. So I thank you, Professor Kapenda. But I'm going to end with the question that the Law Review itself posed as the topic of this panel. Panel 2, starting with Ms. Jeter, and then I'm going to go to Professor Hamlin, and I'm going to end with our native daughter, Professor Crosby. The simple question: where do we go from here, LaToya?
Judge, I think that's a good question. I think where we go from here is that we got to continue to fight. I think that we, as young Americans, we got to remember all that has happened. And I think for me, and even as a lot of young adults, sometimes the privileges that we've been afforded sometimes afford us to forget what has happened. But then we have tragedies that occur, such as George Floyd death. When we watch those things and we're able to see that, you know, the police had their foot on his neck for 9 minutes. Those things bring us back into reality. And although sometimes we seem to forget that, it's ever present. I think where do we go from here is that we got to be vigilant. We got to continue to fight. We have to remind the younger adults even of the importance, and more so importantly, I think we just got to continue to have these conversations and to be open and not to be afraid to accept change and to fight for change.
Thank you. Thank you so much, Professor Hamlin.
I'm going to echo what Ms. Jeter said. I think, you know, as a historian, I think we need to teach our young people their history to try and, you know, help them understand their present by knowing their past. We also need more judges like Judge Kidd, but that only comes from education, right? And sort of educating everyone, black or white, and everyone in between who are coming up as judges and lawyers to understand, again, the history and what's at stake with every decision that's made. I also think, if there's room in law school to have these conversations more often, right? So that folks can step away from what's written in the books to think about the sort of social contract, the culture and what's going on and how they do speak to one another. So thank you for this meeting. And I think it's, if anything else, it's shown that we need to be in conversation and not keep our knowledge separate, but that they can inform each other and be helpful. So I'm grateful to be part of this, and thank you all again.
Thank you so much. I didn't mean to exclude you from this one question, Judge Kidd, but to the extent you want to answer that question, please feel free to do so. Where do we go from here?
Well, first of all, for us judges, judicial canons and not being able to sometimes speak your opinion, all of that comes into play, but it is not extreme. It is not extreme in any manner to demand change after centuries of inequality. And again, that's not a political statement, it's just a reality. And it's a statement of humanity. It has taken far too long for this country to heal. In that healing process, individuals are going to have to just acknowledge the past before we can fully heal. So we have to deal with those issues where individuals can just acknowledge the past, what was wrong. And I think only until we acknowledge the past can we fully heal and move forward.
Thank you, Judge, so very much. And Dr. Crosby, having been here in Mississippi your whole life in your formative years, where would you suggest where do we go from here?
So my mind's going in a million directions. One of the things that I think I've learned a lot about is the intersections, between the local and the national, between the law and lawyers and protests and organizers. And I think this is a really important moment in our country. And I think Mississippi the history can help us move forward as a country. But so in the past few years, when Trayvon Martin was killed and Michael Brown in Ferguson and George Floyd in Minneapolis, among many others, people just said no and just, flooded the streets and said, this isn't acceptable, Black Lives Matter. And they did it not because these are exceptional events, but because they're all too common. And, because people are in the streets saying no, and they're saying Black Lives Matter, we're having conversations now about defund the police and reparations that nobody could have imagined 6 months, a year, 2 years ago. And I think a lot of people, that I talk to react viscerally against the idea of defunding the police. But from my perspective, that what that conversation is really about is addressing the structural racism that we've been talking about, so that police are being asked or allowed or whatever to address everything that we're not doing when it comes to education and healthcare and mental health and housing. We've talked about housing segregation. I've seen some studies that show, there's more police brutality in segregated communities. It's linked to health inequalities, obviously educational inequalities. So these are problems, but I think that the solutions, right? And this is, I think, where Mississippi really has important history to teach us. When organizers, those young people you talked about, went into the Mississippi Delta and connected with people like Amzie Moore, an older generation of strugglers, there was no reason to be hopeful other than the talent and persistence and determination of ordinary people. And I think at this moment, we need that same kind of organizing at its base. So a lot of people looked at what happened in Georgia with the last two elections, the Senate election and the presidential election, but those elections were built on a decade of organizing. And so there, you know, we may not see things as quickly as we want, but I think what we need is this connection of ground level organizing of ordinary people using maybe not the original Constitution, but the Reconstruction amendments and the tools that lawyers bring to the table to really fight for, you know, Black Lives Matter. And I mean, and, you know, people say it, if Black Lives Matter, all lives will matter. And I think we do need to tackle structural racism. And for me, part of that happens through reparations. And I don't know what the answer is on what that looks like, but I think we as a country have to have that conversation. And I think Mississippi can teach us a lot about how to organize and force that conversation on a country that may not want to have it, that does not want to have it. So I just want to give my respects to the people that have taught me and the people in Mississippi who have already made this a better country for all of us.
Thank you so much. Again, hats off to the Law Review. Please, ladies and gentlemen, clap your Zoom way, unmute your phones, clap for this extraordinary panel. I think this was a great way to spend a part of our Friday. This was a great way to spend a part of our Friday, the Friday after Easter for us Christians. This was a great day. This is a great conversation. We know that there's a lot of work to do, and we have to be committed to doing the work. We have to be committed to making our Mississippi and our country a much better place than it was given to us. So I just leave on with that thought, and I'm gonna turn you back over to, as Rudy Huxtable would say, I'm gonna turn you back over to Bud and Mackenzie Ellis. So thank you all so much for tolerating me.
Judge Kidd, you know, Professor Crosby, Attorney Jeter, and Dr. Hamlin, you know, thank you so much for sharing, you know, this afternoon. Really, it was a very real conversation and very frank, and it was refreshing. On behalf of the Mississippi College Law Review, you know, I want to thank each and every person who joined us today. And I want to give a huge shout out again to you, Judge Reeves, for guiding us through today's important discussion. You know, thank you, Dean Bennett and Professor Campbell, our faculty advisor, for allowing us to host the symposium annually and providing us a means to engage with our community. I also want to shout out Professor Kapenda for connecting us with our panelists and allowing us to get together. So thank you, Professor Kapenda. I also want to thank our sponsors, including the ACLU, who is present today on the call. And I want to thank the Law Review Managing Editor, Mackenzie Ellis, and her symposium committee for coordinating this event. They've been working on it all year, and they have done a fantastic job. So in closing, I want to keep the dialogue open. Please feel free to email lawreview@mc.edu if you have any questions, and I will share those questions with today's panelists. So this afternoon, once the meeting recording has populated, I will email all registered attendees the recording link for you to review and share with your colleagues. And I will also email the CLE form that all attorneys should complete and return for CLE credit. So again, thank you all for sharing and engaging and continuing the discussion on racial justice. Have a safe and wonderful weekend. We thank you very much for joining us today. Thank you so much. Thank you.
Thank you.
Appreciate it.